preliminary matter that either team wishes to bring before the court?
Yes, Your Honor. First, we request that, as per the rules of mock trial, we are allowed to screen share as a way to publish exhibits to the jury and show witness statements.
Mr. Littlewood, do you have any objection to that?
I have no objection to that, Your Honor, but I would also request that we be allowed to constructively publish exhibits in addition to that method of sharing.
Do you have a problem with that, Ms. Kidder?
No objection, Your Honor.
All right, then that will be the way we proceed. Anything else?
Yes, Your Honor. We would also request permission to screen share while we are laying the foundation for an exhibit for the benefit of you and our opposing counsel.
Mr. Littlewood?
I have no objection to that, Your Honor.
I will allow that. However, we will also have a rule that we will deem that not to have been shown to the jury until such time as an exhibit is admitted into evidence.
And finally, Your Honor, we request, as per the rules of mock trial, if there are any technical difficulties, that the clock be stopped immediately and that time not count towards either side.
Mr. Littlewood?
No objection, Your Honor.
That's not a problem. So that is adjudicated fairly, if there is a technical problem that arises, please verbally alert the court to that, and more importantly, the timekeepers to that, so that we can stop the time and get the matter resolved. Anything else, Ms. Kidder?
Nothing further, Your Honor.
Okay, Mr. Littleton, do you have any other preliminary matters to bring before the court?
No, Your Honor.
All right, then I guess we are ready to get going. Thank you. Team Mexico, your opening argument or opening statement.
Yes, Your Honor.
Ms. Wendt.
Proceed, Your Honor.
You may.
Motive, mischief, murder. The case today is about someone named Avery Becker, who had a motive to retaliate against the victim, Mackenzie Brackman. The act of retaliation, to vandalize the victim's home, a crime known as criminal mischief. In the process of that mischief, the victim surprised the defendant, they struggled, and the victim, Mackenzie Brackman, was murdered. Good afternoon, members of the jury. My name is Claire Ann Wind, and today I and my co-counsel represent the people of the state of Colorado. In this trial, we are seeking justice for Mackenzie Brackman. Avery Becker had a vendetta against Mr. Brackman. They hated each other. Mr. Brackman was the coach of a mock trial team, and the defendant was the insolent team member. This relationship deteriorated so fast and so dramatically that it created a recipe for murder. This is what the evidence will show. Mackenzie Brackman was a lawyer who volunteered to help coach the Colorado high school mock trial team. The defendant was on that team, and to the defendant, that team was her entire identity. She thrived on, without preparation, dazzling the jury with her theatrical performance. The coach, on the other hand, demanded preparation and practice. These two headstrong competitors clashed continuously, with Mr. Brackman believing the defendant was arrogant and lazy, and the defendant believing Mr. Brackman was a terrible coach and lawyer. How can we know the defendant was capable of committing such a crime, members of the jury? We know it because this was not the first time something like this had happened. Just weeks earlier, the two had a series of arguments, each one building on the other. It all came to a head and they blew up at one another. The defendant's reaction was disproportionate. The defendant caused extensive damage to Mr. Brackman's expensive Porsche car. Mr. Brackman caught her in the act of vandalism and, in anger on the spot, kicked her off the mock trial team. The defendant was determined to retaliate. How do we know this, members of the jury? We know it from the defendant's own words. First, the defendant told her mother, "I will get back at Mr. Brackman if it's the last thing I do." And second, the defendant texted a friend and said that Mr. Brackman was going to be really angry when he sees what I do to his house. I'm going to wait till he's at work, then I'm going to break in and trash it. Members of the jury, the defendant did just that. This motive of retaliation compelled her to commit criminal mischief by breaking into the Brackman home. Only something went terribly wrong. Mr. Brackman surprised the defendant. They struggled, and sadly, Mr. Brackman was murdered. It's not what the defendant set out to do, but under the law of this state, what the defendant did constitutes first-degree murder. Today, we will call 3 witnesses. First, Kyle Cusack, a crime scene reconstructionist and investigator, to testify about the crime scene and how it supports the theory that this was criminal mischief gone wrong. Next, we will call Alex Fuentes, a former classmate and friend of the defendants, to testify about the text messages he received about breaking into the Brackman home. And finally, we will call Jordan Markowitz, the lead detective on this case, to testify about the evidence and how the cell towers placed the defendant's phone in the scene of the crime. The defense will also call 3 witnesses who are not going to be credible. They may try to blame this crime on some phantom named Blair Rowlands, someone they have no evidence for and who is not even here to testify today. We know they're going to call Taylor Perkins, the best friend of the defendant, who will claim to have been with the defendant during the time of the murder. However, there is no evidence to support this friend's story. We know they're also going to call a crime investigator who is a hired gun for criminal defendants. This investigator is paid top dollar to testify for only defendants and did no real investigating in this case. And finally, the defendant will take the stand. She will have to admit that she hated Mr. Brackman, that she vandalized his car, and that she promised to retaliate against him for kicking her off the mock trial team. As the prosecution today, we have the burden of proving beyond a reasonable doubt that Avery Becker committed the crimes of second-degree burglary and first-degree murder, because that is exactly what the evidence will prove, members of the jury. We urge that you find Avery Becker guilty. Thank you.
Thank you. Defense, your opening statement, please.
Yes, Your Honor. May I proceed?
Yes, you may. Your
Thank
camera.
you. What's the matter?
Your camera is, we can't see you.
Oh, one moment then.
There you are. Go ahead.
Perfect. Sorry about that. Your Honor and ladies and gentlemen of the jury, we are complex people with complex problems, and complex problems don't have simple answers. The case the prosecution will present for you today is an attempt to answer a complex problem, Mackenzie Brackman's tragic and untimely death, with a simple answer. Avery Becker didn't like Mr. Brackman and therefore must have killed him. Simple, right? But what you'll see when you look below the surface of the prosecution's case is that their simple answer doesn't make much sense. It doesn't make sense because Avery Becker did not kill Mackenzie Brackman. The defense will present the defendant, Avery Becker, and her alibi, an alibi that was never investigated into by the police on the prosecution side, despite their knowledge of one. Today, instead of speculation on part of the police, Avery will get up on the stand and tell you herself where she was when Mr. Brackman died. She was at the mall with her friend Taylor looking for her missing phone, but you don't just have to take Avery's word for it. Taylor Perkins will also tell you that she and Avery were at the mall looking for Avery's phone on the day of Mr. Brackman's murder, March 6th, and had no intention of ever going near Mr. Brackman's home, especially since they didn't even know his address. Ms. Becker will also illuminate the nature of the relationship between herself and the late Mr. Brackman, how it was one of expected high school frustration, but certainly not murder. Not only this, but Ms. Becker will also testify to her relationship with Alex Fuentes, saying that they were hardly close confidants, certainly not close enough to exchange the strain of text messages received by Detective Markowitz. Most importantly, though, ladies and gentlemen, Ms. Becker will explain how her short-lived, rash behavior after the regional tournament did not push her further into violent behavior, but rather to immediately see the error in her own ways and abandon such behavior. It didn't push her to plan to break into Mr. Brackman's house, but, as she will explain, motivated her to make amends for her past behavior and apologize. The defense will also present Blake Van Owen's investigation into the murder of Mr. Brackman, which takes into account the pieces of evidence the prosecution has ignored. Mr. Van Owen, an experienced private investigator, will explain what exactly happened on March 6th, using detailed analysis on both evidence gathered by the police and evidence the police failed to gather, including the phone records of Taylor Perkins, which showed Perkins in the vicinity of the mall at the time of Brackman's murder, lining up with both Becker and Perkins' alibi. There is no doubt that this case is a complex one and should be treated as such. However, the prosecution has ignored important pieces of evidence and reduced the complexity of the case to a simple answer. As you will see, the clean lines of events Detective Markowitz and Kyle Kuzak have constructed from the evidence they found at Mr. Brackman's home on March 6th is exactly this. Today, the defense will show you that Detective Markowitz initially thought a former client could have killed Mr. Brackman, but failed to investigate any of those former clients, their whereabouts at the time of the murder, or even their names. The detective also failed to interview 7 out of the 9 members of the mock trial team, as well as failed to investigate the phone records of Alex Cifuentes. In short, ladies and gentlemen, the detective failed to investigate any theories that may have contradicted their own simple answer. Similarly, the defense will show that Kyle Kuzak failed to consider that the knife used to murder Mr. Brackman and the knife Mr. Brackman had in his kitchen block were of completely different brands. She also failed to investigate the Ring doorbell records of Mr. Brackman, records which were vital to the line of events displayed in their theory of the case. Not only this, ladies and gentlemen, but the defense will present to you both Mr. Kuzak and Detective Markowitz's striking negligence in investigating any suspects besides the defendant, Avery Becker. Mackenzie Brackman also had a life of his own as a criminal defense attorney, though Kyle Kuzak and Detective Markowitz have narrowed a complex life into the confines of a single high school mock trial team. Ladies and gentlemen, today, as the prosecution said, they must convince you beyond a reasonable doubt that Avery Becker is guilty. The evidence they have built their case on only reveals a simple answer to a complex problem. The defense will make clear that there are pieces of evidence and alternative theories to the case that point in a direction other than a simple linear story, that true justice was ignored in favor of a simple, clean answer. We implore you to cast not guilty. Thank you.
Thank you. Will the scoring panelists complete their sheets for this section? And let me know when you're done.
Holly Ryan, I'm done, Your Honor.
Holly, thank you.
Dalia Labrador, I'm done.
Thank you.
I'm finished. Stephanie done.
Judge, thank you. Prosecution, you may call your first witness.
The people of the state of Colorado call Kyle Kuzak.
Go ahead.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Kyle Kuzak. That's K-U-Z-A-K.
Ms. Kuzak, what is your profession?
I am a Colorado Bureau of Investigation certified crime scene reconstruction investigator, but that's a mouthful, so we just use the term CSR.
As a CSR, will you tell the jury what you do?
Absolutely. I investigate complex crime scenes, including home invasions, burglaries, and other property crimes, homicides, domestic violence, fatal accidents, and armed robberies.
How many years of experience do you have as a CSR?
I have 19 years of experience working as a CSR.
What have you been doing in your most recent years?
Well, for the last 3 years, I have worked for the Denver Police Department.
In the case today, the defendant is being charged with second-degree burglary and first-degree murder. Do you have any experience investigating those types of crimes?
Yes, that's exactly what I do for a living.
Were you involved with this case?
Yes, I was the CSR assigned to the murder of Mackenzie Brackman.
Your Honor, the people of the state of Colorado offer Kyle Kuzak as an expert witness in crime scene reconstruction and investigation.
Mr. Littlewood, do you have any objection?
Yes, permission to voir dire.
Go ahead.
You are not a police officer, correct?
No, I am not a police officer. I am a civilian employee for the city of Denver.
So you haven't been through the same basic training that all police officers go through?
No, I'm a crime scene reconstruction investigator. I am not a police officer.
That's a no.
Yes, I am not a police officer.
Or the same training a police investigator might go through?
I have my training in crime scene reconstruction and investigation.
But you have not been through the same training that a police investigator might go through.
Objection, Your Honor, asked and answered.
Your Honor, if I may respond.
You may respond.
The question was asked, but it was not properly answered.
I think that Mr. Littlewood has some leeway to cross-examine to get the answer he wants, or thinks he needs anyway. Overruled.
I'll ask the question once again. You've not been through the same training as a police investigator.
Why would I go through that training? I'm a CSR, not a police officer.
Thank you. Your Honor, I object to the witness's qualification on the grounds that they do not have the same training or equivalent training to a police officer or police investigator who might typically be offered as an expert witness in a case such as this one.
Response, Your Honor?
Yes.
Your Honor, we are not offering this witness as an expert in police practices or anything to do with the police. Actually, we are offering her as a crime scene reconstructionist and investigator. She certainly most has, under Rule 702, I believe, the knowledge, experience, training, and education to be qualified as such. She does not need to have police training for this qualification.
All right. I didn't hear a lot about what training she had undertaken. However, I think the prosecution's point that she is not being offered as an expert as a policeman, but as a crime scene reconstructionist and investigator is adequate to qualify her as an expert in those fields. So the objection is overruled. Go ahead, Ms. Wind.
Yes, Your Honor. Ms. Cusack, how did you become involved in this case?
I was called to investigate Mr. Brackman's death at 444 South Flower Street on March 6th of 2020.
Please tell the jury what you did to investigate the case.
Well, I've actually developed my own 5-step process for the purpose of crime scene reconstruction, and I applied it here. So first, I created evidence tracking sheets.
Please turn to Exhibit 17, which my co-counsel should pull up in just a second. What is this?
These are my evidence tracking sheets.
And how do you know?
I personally created Exhibit 17.
Is Exhibit 17 a fair and accurate copy of the document that you created?
It most certainly is.
Your Honor, the people of the state of Colorado offer Exhibit 17 into evidence.
Mr. Littlewood, is there any objection to the admission of Exhibit 17?
Yes, Your Honor. I would have two hearsay objections. Firstly, this entire document includes many statements which were created outside of court. Additionally, if the person who's screen sharing would scroll to the second page of Exhibit 17, I believe you will see a sentence that notes that the details on that page are details learned in an interview with Detective Markowitz, which would make this hearsay within hearsay.
All right, thank you. Ms. Wynn, do you have a response?
Yes, Your Honor. This is an exception to hearsay under Rule 803.6, a record of irregularly conducted activity. This is something that Ms. Cusack does often in her investigations, creates these evidence tracking sheets. She made this herself. She can certainly authenticate it. And it's something, like I said, she has regularly done in the course of her job and her certifications. And therefore, it is a record of a regularly conducted activity and is an exception to hearsay under Rule 803.6.
Well, the evidence that I heard was that this was a procedure or a fact tracking system that she developed herself. I didn't hear any testimony that this is regularly conducted activity.
I can lay more foundation if you require, Your Honor.
I think you need more foundation, yes.
Yes, Your Honor. Ms. Cusack, when you are completing your investigations, do you regularly follow your 5-step process?
Yes, I do.
So do you always create evidence tracking sheets for the cases you investigate?
Yes, ma'am, I do.
Your Honor, we once again offer Exhibit 17 into evidence.
Mr. Littlewood?
Yes, Your Honor. I would stand by my hearsay objection. I do believe that on some of these statements can qualify as not being hearsay under the rule that excludes records of irregularly conducted activity. However, I would stand by the hearsay objection that discusses hearsay within hearsay. The statements learned in the interview with Detective Markowitz are not records of irregularly conducted activity and therefore would still be considered hearsay.
Well, I have a question, Ms. Wynn, for you, and that is whether this fact tracking system is something that is regularly performed by the Denver Police Department, or is this a unique activity and process conducted by Ms. Cusack?
Your Honor, because Ms. Cusack is not technically, she is a civilian police employee. This is not something that the Denver Police Department would do, but it is definitely something that she has learned from crime scene investigators in her course of training and such. So other investigators, I do believe, use this same process, but it would not be general for the Denver Police Department.
So it's not the regularly conducted activity of a government entity. And don't you need that?
No, Your Honor, it is simply her regularly conducted activity. That's
Okay.
all we need.
Well, it seems to me that you haven't established that this is a regularly conducted activity by the entity, which I think you need to make this a business record. Additionally, it seems that, well, for the exception of a business entity, regularly kept record to work as an exception under the hearsay rule, it has to be something that, at least in my view, has to be a matter that is conducted by a business or a government entity on a regular basis, on a regular systematic matter that is not related to putting something into that, is that it can be treated as a reliable entity because it's not being.
I believe you cut out for a moment, Your Honor.
A phone call. That's not being created for the purposes of trial. And in this case, it doesn't meet that. This is something that is uniquely created by the witness for the purpose of testifying. So I'm not going to admit it, and I'm going to sustain the objection that the matter is not admissible. However, I am going to allow it to be used by Ms. Cusack as a demonstrative evidence because it appears to be the summary of the work she has done, and she can use it to explain the processes she went through.
Yes, Your Honor.
You understand the distinction?
Yes, Your Honor.
Thank you, Your Honor.
Mr. Littlewood?
Thank you, Your Honor.
Okay, go ahead, Ms. Wind.
Yes, Your Honor. Ms. Cusack, the defense alleged in their opening statement that the police limited their investigation to Avery Becker. Is that true?
No, as Exhibit 17 would show if we were allowed to look at it, the police looked at 3 suspects. The primary suspect was Avery Becker. The secondary was Alex Cifuentes, and the tertiary suspect was Blair Rollins.
Do you have an understanding?
Ms. Wind, to clarify, my ruling was that the Exhibit 17 may be used as a demonstrative evidence, meaning that the witness can look at it, can refer to it, is just not admitted as substantive evidence. Okay?
Yes, Your Honor. That was as much as we needed to talk about it.
All right, go ahead.
Just real quickly, Ms. Cusack, do you have an understanding of why the police ultimately focused on Avery Becker as the primary suspect?
Well, there was absolutely no evidence whatsoever that anyone else was involved in this crime.
All right. And what did you do after you created your evidence tracking sheets?
I went to the crime scene after it was processed by the crime lab. I collected the police reports, the photographs, several videos from 3 different Ring security devices, and a copy of the official autopsy report.
What did you find at the crime scene?
I saw the Ring videos and their video footage. I saw scuff marks near the back door. There was an open drawer with several knives in it, as well as a knife block on the counter with an empty slot in it, perfect for a chef's knife. There was also a broken plate near the kitchen table, and there were certain small blood droplets leading to the front door, as well as a large pool of blood and a bloody chef's knife near the front door.
Objection, Your Honor. This question has created a narrative.
Sorry, I can't hear what you're saying, Mr. Littlewood.
Your Honor, this question has created a narrative.
Ms. Wind?
Yes, Your Honor. The question was, I asked the witness what she found at the crime scene, and she was merely describing that. It is quite a bit of evidence, but my witness actually just finished her answer.
All right, then let's go by question and answer a little more than just unrestrained narrative. Go ahead.
Yes, Your Honor. What did you do next, Ms. Cusack?
I watched the videos from the Ring cameras.
Please turn to exhibits 10 through 13. which should show up in
There.
just a second. What are those?
Those are the ring videos showing footage from the day of the murder.
And how do you know?
I was at the crime scene and I've observed the cameras, and I received these videos from Detective Markowitz.
Are exhibits 10 through 13 fair and accurate copies of the videos you received from the Brackman home?
Yes, they are.
Your Honor, the people of the state of Colorado offer exhibits 10 through 13 into evidence.
Mr. Littlewood,
No objection, Your Honor.
then exhibits 10 through 13 are admitted into evidence.
Ms. Cusack, for time's sake, will you walk the jury through just one of these exhibits? Exhibit 11, please.
Absolutely. This is Exhibit 11. It shows someone matching the height and build of the defendant entering the residence wearing a Halloween mask, gloves, and baggy clothing.
Objection, Your Honor. This is cumulative evidence. Once an exhibit has been admitted into evidence, it is supposed to speak for itself.
Ms. Wind, do you have a response?
Your Honor, the witness was simply clarifying for the jury, and she is done now. We can show the video again without her talking if counsel would prefer that.
Mr. Littlewood?
Your Honor, no additional information was brought in through the testimony regarding the video or through showing the video itself, really, and therefore is cumulative since anything admitted in the evidence is supposed to speak for itself without further testimony.
Well, I think that the prosecution has the opportunity to display the evidence, the exhibit that it is relying upon to the jury. And the testimony from Ms. Cusack during the showing of the video indicated that the person seen in the video matches the height and weight, general physical description of the defendant, which I think is pertinent and therefore admissible. Overruled. Go ahead, Ms. Wynn.
All right, Ms. Cusack, let's take a step back and talk about the victim for a minute. How did Mr. Brackman die?
He was stabbed near the shoulder blade. A knife penetrated his aorta, and when it was removed, he bled out and died.
After you visited the crime scene, what did you do?
I reviewed all the information and evidence I had collected and what I had viewed in the home. I analyzed it and I reconstructed the crime scene.
And what did your reconstruction show?
The evidence clearly pointed to a home intruder, most likely a burglar, who entered the residence at a time of day when Mr. Brackman would not have normally been home. Remember, this was pre-COVID, when people actually went to an office to work. However, Mr. Brackman was home that day. He grabbed a knife in order to defend himself, struggled with the intruder, and was killed.
Objection, Your Honor. Speculation. I don't believe that and in addition, lack of foundation. I don't believe that the proper foundation has been laid as to how the witness arrived at these conclusions. And in addition, I don't believe that based off of the testimony that has been brought in so far, these conclusions could have been reasonably arrived at by the expert.
Ms. Wynn?
Your Honor, we have qualified this witness as a crime scene reconstructionist and investigator, and she previously discussed what she had found at the crime scene and how she reviewed all of her evidence. What she has previously stated just then is simply a summing up of what all of the evidence that she had previously stated brought her to, what conclusions all of that evidence brought her to, and as such, it is reasonably based on her expertise and is not in any way objectionable.
Well, I think that she reached some pretty broad conclusions and offered some pretty broad opinions as to what happened. I didn't hear a lot of the underlying evidence. However, she is here as an expert to give her conclusions as to crime scene reconstruction. If you, Mr. Littlewoods, find that those conclusions are not adequately supported, I think you can dive into that on cross-examination. So at this point, I'm going to overrule the objection.
May I continue, Your Honor?
Yes, you may.
Ms. Cusack, you just testified that Mr. Brackman had a knife. What about the suspect? Did they have a knife with them when they entered?
Although it is possible, the videos show no evidence that the suspect had a knife on them, and it would have been extremely difficult to carry that large of a knife in those loose sweatpants. Because of this, I believe that the knife came from Mr. Brackman's knife block.
Why do you believe that?
Well, when I analyzed the crime scene, there was only one empty slot in the knife block, and it happened to be of the right shape and size to store the chef's knife that was used to commit the murder.
Was the chef's knife of the same brand as the rest of the knife block?
No, the knives and the knife block were from a more expensive set, but we did not find that knife. So it's likely that Mr. Brackman simply replaced the damaged knife.
Ms. Cusack, did you come to any conclusion about whether Avery Becker committed this crime?
No, my job is to reconstruct crime scenes so that the detectives can use that information to determine who committed the crime.
And in your reconstructions, did you come to any conclusions?
Yes, I most certainly did.
In your expert opinion, what happened at 444 South Flower Street on the day of the murder?
This was clearly
Objection, Your
a
Honor.
planned break-in.
Objection, Your Honor. This question calls for a narrative answer.
Ms. Nguyen?
Your Honor, the witness had almost finished her answer. Although counsel may believe it calls for a narrative answer, I'm not asking the witness to narrate. I'm simply asking what her expert opinion is. I can break it up further, but I don't see how it could possibly call for a narrative since the witness hasn't even answered yet.
Your Honor, if I may elaborate.
Yes.
This question asks for the witness to discuss what happened at at a certain location on a certain date. That is overly broad and could easily create a narrative.
Well, I agree it could. She's also called as an expert to reach certain conclusions, which apparently she has, and she has been asked to state what those conclusions are. At this point, I don't really have a basis preemptively to stop her from stating those conclusions if it becomes overly long and becomes a narrative, and that doesn't allow you to object properly, then we can revisit it. But at this point, I'm going to overrule the objection and hear Ms. Cusack's answer.
Let me ask that question again, Ms. Cusack. In your expert opinion, what happened at 444 South Flower Street on the day of the murder?
This was clearly a planned break-in gone bad.
Please explain.
Well, the intruder had knowledge of the victim's property and chose a time of day when the victim's patterns would have placed him outside the home.
Objection.
Now,
Speculation. I don't believe that the proper foundation has been laid as to how this witness might know what the intruder knew about Brackman or really what they knew at all.
Ms. Wind?
Your Honor, we have qualified this witness as an expert in crime scene reconstruction and investigation. She is perfectly qualified to give her expert opinion on what happened that day at a crime scene that she herself reconstructed and investigated, and as such, it cannot possibly be speculation.
Your Honor, if I may respond.
No, I don't need a response. She's been qualified as an expert witness in crime scene investigation. The answer that she was preparing to give and started to give consisted of statements about planning for the crime, planning for the event, arriving at the crime, timing it to avoid the presence of the victim, none of which is within her previous testimony or with any basis for us to know why she is or how she came to her conclusions as to those matters. So I think in this case, Mr. Littlewood is right, and I'm going to sustain the objection.
Thank you, Your Honor.
Yes, Your Honor. Ms. Cusack, in your investigations, did you review police reports and other items as such?
Yes, I reviewed all the police reports, all the photographs, all the videos from the ring security cameras, and the official autopsy report, and I reached my conclusions by doing that.
And after doing all of your research and all of your expertise going into this, what conclusions did you reach about what happened that day?
The intruder clearly had knowledge of the victim's patterns. He chose a time of day when the victim would not have normally been home. Mr. Brackman was either alerted to the victim's presence.
Objection. I would once again object on speculation. I don't believe there is any basis for the witness having knowledge of what the intruder knew at the time that they entered the home.
I agree. Sustained.
All right, Ms. Cusack, let's continue. So when you reviewed all of this evidence, what happened, do you believe, after reconstructing the crime scene and seeing how that played out, what do you believe happened in the home?
Most likely, the intruder struggled with Mr. Brackman, somehow got a hold of that knife, and fatally stabbed Mr. Brackman, and Mr. Brackman died.
Do you believe that the intruder was intending to kill Mr. Brackman?
No, all the evidence points to the
Objection,
fact.
Your Honor. Speculation.
Ms. Nguyen?
Your Honor, this is once again not speculation. This witness has testified about how she has investigated the crime scene, reviewed all of the police reports, any conclusions or opinions I'm asking her to come to in this case are reasonably based on her expertise and her knowledge in this case, and therefore this cannot
Ms. Nguyen-
possibly.
Ms. Nguyen, that recitation of what she did, we've heard several times. I think the question is, what is it that she looked at that supports the conclusion that she's attempting to testify to?
Would you like me to answer that, or was that a rhetorical question?
No, well, it's a rhetorical question in that it is your obligation and the witness's responsibility to provide some facts for the basis of her conclusions, other than her general activity of reviewing everything and coming to a conclusion.
All right. All right, Ms. Cusack. So I just have one last question for you. Is your testimony here based on facts and evidence?
Yes, ma'am, it is.
Have reasonably come to your conclusions?
Yes, ma'am, I did.
And so after reasonably coming to those conclusions, you say you have reviewed the ring videos, correct?
Yes, ma'am, I did.
And you reviewed the police reports?
Yes, ma'am, I did.
And so what conclusion did you come to about whether or not the intruder intended to kill Mr. Brackman?
Objection, Your Honor. Once again, I would object to speculation. I don't believe that there is any basis for this witness knowing what the intruder's intentions were when they entered the home.
Ms. Nguyen, beyond the fact he looked at police reports, put another way, what in the police reports or in the ring video or in any other witness or any other evidence that they looked at leads her to reach a conclusion as to what was in the assailant's mind when the assailant went into the house?
Because the intruder did not carry a knife with them when they entered the house, Ms.
Well,
Cusack
I
came
think
to.
that's what Ms. Cusack has to tell us.
Okay. Ms. Cusack, if you would please explain to the jury how you came to the conclusion that the intruder did not originally intend to kill Mr. Brackman.
Objection,
Well-
the facts not in evidence. The fact that the intruder did not intend to kill Mr. Brackman has not yet been entered into evidence, as it has been kept out by numerous objections.
Well, in this case, I think you're overreaching a little bit, Mr. Littlewood, because what she was about to tell us were the facts that she relied upon to reach a conclusion. And I think the jury wants to hear that, so overruled. Go ahead, Ms. Cusack.
Could you please ask the question again?
Yes, ma'am. What evidence did you rely on to come to the conclusion that the intruder did not originally intend to kill Mr. Brackman?
Well, the intruder went to the house at a time of day when most people would have normally been at work, because this was pre-COVID, so people would actually go to an office. Second, they checked the first door and the second door, and the back door was open, so they were able to enter the residence. Mr. Brackman,
Keep going.
Mr. Brackman was home that day, and as evidenced by the open knife drawer and the knife block on the counter with the empty slot in it, and not being able to find the knife that went into that slot, it's clear that Mr. Brackman got a knife from either the drawer or the knife block to defend himself, and struggled with the intruder based on the scuff marks and the broken plate, and his own death resulted from that struggle.
Thank you. I have no further questions, Your Honor.
All right, thank you. Mr. Littlewood, do you have cross-examination?
Yes, Your Honor.
Go ahead.
I'm going to start with some questions about the security camera footage. You are aware that push notifications can be turned off on the ring app.
Yes, but I don't see why someone would have a complex security system like that and
But
not
they
have
can be-
notifications
they can
turned
be
on.
off. That's a yes.
What?
They can be turned off. That's a yes.
Yes, they can be.
And you did not obtain records from Ring to see if the victim had disabled push notifications.
No, I did not do that.
And you reviewed Professor Blake Van Owen's report for this case.
Yes, sir, I did.
So then you are aware of Blair Rowland's involvement as a possible suspect.
Yes, I am aware of Blair Rollins.
In fact, you regarded Blair Rowlands as a possible suspect as well.
Yes, I've already stated that.
And you learned that the victim in this case represented Blair Rowland's father in a separate case.
I don't know that. I cannot answer that question. I do not know that answer.
So you never conducted any investigations into Blair Rowlands then?
The only thing I know about Blair Rollins is she is an unlocated party.
You never tried to find her?
My job is to reconstruct crime scenes so that the detectives can investigate suspects.
That's enough. You never did any investigations into Blair Rowlands.
My job is to reconstruct crime scenes, not to investigate suspects.
That's enough. That is enough.
I did not investigate Blair Rollins because that was not my job.
Let's move on. And you used a flowchart, as previously mentioned, to keep track of case details for this case.
Yes, I did.
And as noted on that flowchart, many of the details within are details you learned from an interview with Detective Markowitz.
Yes, many of those details are.
Now moving on to some of the material evidence, it is your opinion that the knife the victim was stabbed with came from the knife block in the kitchen?
Well, it would have been extremely difficult for the suspect to carry that large of a knife, a 12-inch chef's knife, in their baggy clothing. And the videos show no evidence of them carrying the knife in their hand. So they would have had to disguise it in that baggy clothing.
That's a yes, that was the conclusion. That was the conclusion. Thank you. And this knife had the knife used as the murder weapon had a silver blade and handle cast from one piece of metal.
Yes, it did.
And the knives in the knife block all have black handles?
Yes, Mr. Brackman probably replaced a damaged knife with
They
the
all have
silver
black
knife.
handles. Yes.
Yes, the knives in the block had black handles.
And upon further inspection of the knife used as the murder weapon, you discovered it was a Chicago cutlery knife?
Yes, it is a Chicago cutlery knife.
Meanwhile, the knives in the knife block were from a J.A. Henkel's knife set.
Yes, I think we've already gone over that.
So the murder weapon was a different color than the knives in the knife block.
Objection, Your
Yes,
Honor.
but like I said,
Sorry, your objection, Ms. Wind?
Objection, Your Honor, asked and answered. Counsel has already reiterated this point. My witness already stated that the knives in the block were of a different brand. I'm not sure where counsel is going with this or why he feels the need to keep asking the same question.
Your Honor,
Well,
if I may respond.
I guess that's all right, Mr. Littlewood. I don't think I need a response because he has the ability to conduct his cross-examination in the manner that he sees fit. He doesn't have to satisfy your expectations of how he's going to do it. And the questions that he asked, although they increase our knowledge only by small increments, they are different questions. So the objection is overruled. Go ahead, Mr. Littleton.
So then the
Wood.
murder weapon was a different color than the knives in the knife block.
yes, I've already stated that Mr. Brackman just probably replaced the damaged knife that was in the J.A. Henkel's knife set with the Chicago cutlery knife.
They were a different color
Yes, I've already said that.
and a different style as well.
What do you mean by style?
Generally of a different make. For example, you previously testified that the handles of the knives in the knife block were of black plastic, correct?
I did not previously testify to that, no.
You did not previously testify that the knives in the knife block had black handles.
No, I never said that.
May I direct your attention to line 86 of your witness statement?
Yes, just give me a moment, please. Line what, 86?
Yes, 86.
86. Okay, I'm there.
Do you see where it says that Exhibit A is a fair and accurate representation of the knives and the knife block?
It says that Exhibit 8 is a photograph of the knife block.
Thank you. Now may I direct your attention to Exhibit 8?
Yes,
Can you please identify Exhibit 8?
this is Exhibit 8. It is a photograph of the knife block. The knives do have black handles. I just never said that out loud or in my witness statement.
Okay, but the knives do have black handles.
Yes, if that's what your point was, yes, they do have black handles.
So then the styles of the blades were generally different.
Well, they were both knives, but the color was different.
And they were also a different brand.
Yes, they were a different brand.
Thank you, Your Honor. No further questions.
All right, thank you. Ms. Nguyen, do you have any redirect within the scope of the cross?
I believe so, Honor. First, may I ask for a quick time check?
Yes.
You have 15 minutes, 23 seconds on my clock.
All right. Then I will continue with my redirect if that is allowable, Your Honor.
Go ahead.
Thank you. Ms. Cusack, why were the knives in the block of a different brand than the knife used to commit the murder?
Well, we didn't find the knife that fit in that slot in the knife block. So it's likely that Mr. Brackman simply replaced that damaged
Objection, Your
knife
Honor.
with the silver knife.
Objection, Your Honor. Speculation.
Ms. Nguyen?
Your Honor, this is a reasonable assumption that any person could come to, and as Ms. Cusack is an expert witness in crime scene reconstruction and investigation, she certainly has enough experience and knowledge as well as training to come to conclusions about the crime scene that she reconstructed.
Your Honor, there are many possible explanations for an empty slot in a knife block. The witness is simply speculating as to which one of these explanations is correct.
Well, I think you can point that out on cross-examination, Counselor. So overruled. Go ahead.
Right. So just to reiterate, Ms. Cusack, the knives in the block were of a different brand because I'm sorry.
Because Mr. Brackman most likely replaced a damaged knife. Yes.
Thank you. I have no further questions, Your Honor.
All right. Do you have any recross within the scope of the redirect, Mr. Littlewood?
No, Your Honor.
All right, thank you. Then the witness is excused. The scorers can complete their sheets and let me know when you're done.
I'm finished, Your Honor.
Thank you.
I'm finished, Your Honor.
Thank you.
I'm finished, Your Honor.
Thank you. Prosecution, your next witness.
The people of the state of Colorado call Alex Cifuentes.
Mr. Cifuentes, I remind you, remain under the oath you took at the beginning of these proceedings.
Yes.
Thank you. Mr. Holtzinger, go ahead.
Good afternoon. Please introduce yourself to the jury.
My name is Alex Cifuentes, and I know that's kind of an unusual last name, so I'll spell it for you. It's Sifuentes.
Mr. Cifuentes, do you know the defendant?
Yeah, Avery and I have been best friends for years.
Your Honor, the people of the state of Colorado ask that the defendant briefly turns on their screen for the purposes of an identification.
All right, would the defendant please turn on the screen, her screen? There we go.
Mr. Cifuentes, do you see the defendant on your screen?
Yes, I do.
What color is her hair?
It appears it's brown.
Your Honor, let the record reflect Mr. Cifuentes has identified the defendant as Ms. Becker.
It shall do so.
And she may also turn off her screen at this time.
Thank you, Ms. Becker.
Mr. Cifuentes, where did you spend the most time with the defendant?
We were both on the Colorado High School mock trial team.
Why did you join the team?
It was actually Avery who convinced me to try it out in the first place. And it sounded super cool.
As you know, the defendant is on trial for the murder of Mackenzie Brackman. Did you ever have any opportunity to see Mr. Brackman and the defendant interacting?
All the time.
In what context did you see them interacting?
At her mock trial practices and competitions.
Based on your observation, how would you describe their relationship?
It was terrible. They were always really frustrated with each other, and it seemed like they hated each other.
Objection, speculation. As much as this witness is testifying on their perception, they cannot comment on the actual inner feelings of the people in question.
Mr. Holzinger?
Your Honor, under Rule 602, this witness has personal knowledge as to their relationship. My questioning is not asking Mr. Cifuentes to testify about anything inside of their heads, but his rational perception of and his observations based on physical actions that he has perceived. Later, he will testify as to a conflict between the defendant and Mr. Brackman, and that sort of an observation of an actual action that took place establishes his knowledge of this relationship.
Mr. McKinney?
The objection stays, Your Honor.
All right, well, I think that the question reasonably asks for an observation from the witness and the inferences that he has drawn from it, and therefore it's overruled. Go ahead, Mr. Holzinger.
Mr. Cifuentes, how do you describe the relationship between the defendant and Mr. Brackman?
It was very tense. They were always really frustrated with each other, and it kind of seemed like they hated each other.
Did you ever see any actual conflict between the two of them?
Yes. One day, when Avery was late to practice, again, Mr. Brackman got big mad.
Could you tell the jury what happened after Mr. Brackman got so mad?
Mr. Brackman demoted Avery to the B team.
What happened after the defendant got demoted?
Taylor Perkins, who was good friends with Avery, quit the team. That forced Mr. Brackman to put Avery back on the A team.
How did the team do after that?
At regionals, we advanced to state. Avery won Best Attorney and Best Closing Argument awards.
Did those awards make things better between the defendant and Mr. Brackman?
No way. Just the opposite.
Objection, this is also speculation. Once again, based on observations, one can comment on this. However, this question does call for speculation as it's asking if the relationship improved.
Mr. Holzinger, you have a response?
Yes. If allowed to testify, Mr. Cifuentes would go on to say that their relationship deteriorated based on the fact that Mr. Brackman got angry at the defendant verbally, and the defendant quit the mock trial team, or she left the mock trial team.
Mr. Holzinger, what the witness may be saying in the future is not exactly pertinent to the objection, which is a question that the defense counsel believes asks for speculation. So why does this question not ask for speculation?
Your Honor, it does not ask for speculation because Mr. Cifuentes is only testifying based on rational observations that he made of actions between the defendant and Mr. Brackman, which goes to their relationship after the mock trial competition.
I agree. Overruled. Go ahead.
Mr. Cifuentes, what happened after the mock trial competition?
After the mock trial competition, Avery, excuse me.
I can rephrase the question for you. Did the mock trial awards after the competition make things better between the defendant and Mr. Brackman?
No, just the opposite, actually. At the next practice, Mr. Brackman was super critical of Avery for not preparing despite those awards.
Did Mr. Brackman's comments have any impact on the defendant that you perceived?
Avery got very angry and left practice.
Could you tell the jury what happened after the defendant left practice?
I saw Avery grab a permanent marker on the way out, which seemed kind of weird.
What happened after the defendant grabbed a permanent marker?
Mr. Brackman had a dope car, a 1986 Porsche 911, and Avery wrote Worst Attorney Award in permanent marker on it.
What happened after this act of vandalism?
Mr. Brackman kicked Avery off the team completely.
How did the defendant respond to being kicked off the team?
Objection.
Avery.
This line of questioning calls for improper character evidence under 403.3 section B. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, in this case, the crime in question, the murder, that character, Avery, acted in accordance with that character. So far, the opposing counsel is suggesting a character trait of violence and vandalism. This is a character trait.
Mr. Holzinger?
Your Honor, this testimony is not being used to prove the defendant's character for any sort of trait. It is being used to state what occurred leading up to the events of the murder, and is therefore doesn't qualify for Rule 403 because it's not being used to prove character.
What I heard the question to be was what happened next, and what actions did the defendant take? That may be used by the jury to infer something about the defendant. However, it's not proving or attempting to prove anything about his general character. So I'm going to overrule the objection. Go ahead, Mr.
Mr. Cifuentes, how did the defendant respond to being kicked off the team?
Avery wanted to get back on the team. I wanted me to help her get back on the team. And I tried to help her, but there was no way Mr. Bracken was going to let her back on the team after what she did to his car.
After the vandalism incident and the defendant getting kicked off the team, did you communicate with the defendant in any way?
Yes, by texting.
Please turn to what has been marked as Exhibit 14.
Okay. There it is.
Do you recognize Exhibit 14?
Yes, I do.
What is Exhibit 14?
It is a screenshot of a text conversation between me and Avery.
How do you know?
These messages were sent to my phone, and I was the one who captured the screenshots.
Is Exhibit 14 a fair and accurate copy of the screenshots you captured of your conversation with the defendant?
Yes, it is.
How do you know it was the defendant who is texting you and not someone else?
Well, we have texted many times. Her number was saved into my phone, and we were talking about things personal to her that only she would know.
Later, we believe opposing counsel is going to allege whether or not these screenshots were doctored or manipulated in any way. Did you doctor or manipulate these screenshots?
No way. I don't even know how to do that. These were the messages we sent each other.
Your Honor, the people of the state of Colorado offer Exhibit 14 into evidence.
Mr. McKinney, do you have any objection to Exhibit 14?
Yes, Your Honor. Despite the word that these are authentic, Rule 1003 of based on authenticity of duplicates, a general question of authenticity can be raised if the duplicates provide a genuine question of that authenticity. Under authenticity, Rule 901, where opposing counsel has to prove that these text messages are what they say they are. In addition, that makes this also hearsay, as it is an out-of-court statement that is unauthentic.
Mr. Holsinger.
Your Honor, though 1003 states that duplicate is, Rule 1004 states that the admissibility is only called into question if the screenshots themselves are called into question. We believe that a sufficient foundation has been laid by Mr. Cifuentes that these are the text conversations that he received from his cell phone. These are the screenshots he captured of that conversation. They're not doctored or manipulated in any way. And any further question as to the foundation of these screenshots goes to the weight and not the admissibility of this exhibit. For the hearsay objection, could counsel specify whether or not it's hearsay on the defendant's part or Mr. Cifuentes' part?
Yes, this is an out-of-court statement, which makes it hearsay. And in addition to the authenticity, there's no timestamps, dates, or phone number present, as in there's no clarification of who these people even are.
Your Honor, I believe I had already responded that sufficient foundation has been laid as to the authenticity of these documents, and any further question to the foundation goes to the weight and not the admissibility of this exhibit. As to the hearsay, from the defendant, under Rule 801D2, the defendant's statements are not hearsay because they are a statement by a party opponent. As to Mr. Cifuentes' statements, they're not being offered for the truth of the matter, but for the effect they had on the listener. In this case, Mr. Cifuentes' comments spurred the defendant to respond in the way that she did, and the way that we'll be using this exhibit is calling into question the defendant's statements and not Mr. Cifuentes' statements. However, if Mr. Cifuentes' statements were excluded, this would make this an incomplete exhibit. And so therefore, Mr. Cifuentes' comments are being offered for the effect on the listener and are not hearsay.
Okay, well, I think that I'm going to admit the exhibit. And I understand, Mr. McKinney, that you have objections or concerns about the authenticity of it and have reasons to suspect that it has been doctored. And I think that that is something that can be taken care of by you on cross-examination. And as counsel says, it's a matter of weight rather than admissibility. So the objection is overruled. Exhibit 14 is admitted. Go ahead, Mr. Holtzinger.
Mr. Cifuentes, just to clarify, what color are your words in the exhibit?
Green.
When the defendant found out that she would not get let back on the mock trial team, how did she respond?
Well, if he's still upset about his car, then he's gonna be really upset when he sees what I do to his house. And then she said, I'm gonna wait until he's at work, then break in and trash it. That'll show him.
Mr. Cifuentes, how did you become aware of Mr. Brackman's murder?
A detective called me about it.
What did the detective want?
The detective wanted to talk with me and also wanted screenshots of a text conversation between me and Avery.
What did you do after talking to the detective?
I had the screenshots on my phone and I emailed them to the detective.
Did you also talk to anyone who worked for the defendant?
Yeah, Avery had some sort of weird private investigator try to talk to me. I did not want to, but she insisted.
How did that go?
Oh, it was just awful.
Objection, this question calls for a narrative. In terms of how did that go can be answered with any kind of range of comments.
I'll sustain that objection.
All right.
Mr. Point.
Oh,
Go ahead.
All right, Mr. Cifuentes, did your conversation with the police detective go well at all?
No, it was awful. She tried to get me to lie. She wanted me to say that I faked the text messages
Objection,
with Avery.
speculation. This witness is testifying as to what the private investigator wanted, and that cannot be concluded by this witness.
Well, the testimony was, as I understood it, that this is what the private investigator asked the witness to do. And for that reason, it's not speculation. He can testify to that and overrule.
Mr. Cifuentes, let me repeat the question. What did the private investigator, did the private investigator say anything to you?
Yes, she tried to get me to lie. She wanted me to say that I faked the text messages with Avery, which I obviously didn't.
Later, we will hear allegations that someone stole the defendant's phone. Did you steal the defendant's phone?
No way. Why in the world would I do that?
Finally, did the defendant have a reputation among the mock trial team?
Oh, yes.
Objection, speculation. This witness cannot comment on to the feeling or reputation this defendant had given to other people and their state of mind.
Mr. Holtzinger?
Your Honor, under Rule 405, we are proving the defendant's character through reputation or opinion, and since Mr. Cifuentes was on the mock trial team with the defendant for numerous years, we believe that sufficient foundation has been laid that he can testify as to the reputation of the defendant on the mock trial team.
Well, I guess my question for you is, what is his reputation? How is his reputation relevant to the case you're putting on?
Your Honor, we are trying to establish that the defendant had a reputation to make things up on the witness stand as a witness and to lie and had bad work ethic, which leads to our theory for the relationship between the defendant and Mr. Brackman, which goes directly to our theory for why the defendant committed this crime.
What is his propensity, as you call it, to make up things on the witness stand have to do with this case, other than your attempt to pre-impeach the defendant?
Your Honor, we believe that why can't I think of the word? So what we're trying to say is that this character for making things up on the witness stand was enough to make Mr. Brackman angered by the defendant, and that goes directly to their relationship, which is relevant in proving why the defendant wanted to commit this crime. And so that character trait is a direct result of these practices and competitions, and that's why it's relevant.
If I may respond, Your Honor.
Well, I think that's, go ahead.
On that case, if they're trying to demonstrate the character traits of this witness, that directly goes towards improper character evidence under 403.3. Evidence of a crime, wrong, or other act is not admissible to prove a person's character based on the traits. And they would not enact in accordance to that trait. And their opposing counsel just clarified that they're trying to demonstrate traits.
Well, I think what the explanation of counsel as to the relationship between a propensity to make up things on the witness stand and the relevance to the issues in this case are so attenuated that I just don't see it. So I'm going to sustain the objection. Go ahead, Mr.
Cifuentes. All right, Mr. Cifuentes, did you ever observe any character trait from the defendant when she was on the witness stand in mock trial?
Yeah,
Objection.
Avery.
This once again goes towards character trait. It's the question really hasn't changed that much. This is once again trying to prove character traits, and the defendant acted in accordance to that character trait.
Your Honor, if I may, I can restate the question. I can rephrase it.
I think you have to, because I think you're getting worse instead of better.
Mr. Cifuentes, all right. Mr. Cifuentes, what did you observe the defendant to usually do in their mock trial competitions in terms of her performance as a witness or an attorney?
Avery could do this crazy thing on the witness stand where she made things up and convinced the judge and jury that it was completely true.
Objection, relevance.
I'm sorry, what's the nature of your objection, Mr. McKinney?
I said relevance. Whether Avery's behavior in mock trial does not, specifically to relation to the judges and jury, and once again character traits, is not relevant to the question, to the case at hand.
Okay, Mr. Holsinger.
Your Honor, under Rule 401, Under Rule 401, evidence is relevant if it tends to make a fact of consequence more or less probable. The fact of consequence that we're trying to prove is the relationship between the defendant and Mr. Brackman, and the defendant's performance in these mock trial tournaments goes directly to their relationship and is therefore relevant in proving that that consequence was, that fact and consequence is more probable.
Well, again, that's very attenuated. I don't understand how the performance of the defendant is going to affect the relationship when we have a whole bunch of other direct evidence as to what their relationship is. So I'm going to sustain the objection.
Thank you, Mr. Cifuentes. No further questions.
All right, thank you, Mr. McKinney. You have cross.
Yes, Your Honor.
Go ahead.
You were on the mock trial team with Avery Becker and Taylor Perkins for 3 years, correct?
Yeah.
Impressive, Mr. Cifuentes. All that time, you must constantly be around Mrs. Becker.
Oh yeah, I was around Avery all the time.
And teams are close, and you and Avery were friends, correct?
Oh yeah, we were best friends. We saw each other at school. We'd hang out, stuff. We loved each other.
That's great to hear, but it was you who thought Avery had a lackadaisical attitude towards mock trial in your eyes.
Yeah, she never really came prepared, you know.
And after a dispute between Brackman and, oh, sorry, wrong question. You even asked Coach Brackman why he even put up with her.
Objection, Your Honor, hearsay.
May I respond,
Mr. McKinney, hearsay objection.
Your Honor, this is not testifying to a comment made by another. oh, sorry. This is not a comment by another person. This is simply the testimony of this witness. I'm not commenting on any other comments by other parties.
Your Honor, under Rule 801, any statement that is out of court and is being offered for the truth of the matter is hearsay. Even despite the fact that this is the witness on stand, it's any statement that is out of court. And so therefore, Mr. Cifuentes' own statements do fall under hearsay.
If I may respond, Your Honor.
Well, first, there's some technical difficulties, at least with my machine, where people are breaking up, freezing, and then talking over not meaningfully talking over each other, but mechanically, the machine is talking over each other. I don't see how asking a question, if I understand what the situation is, of whether Mr. Cifuentes asked the coach something is hearsay, and therefore it's overruled. Go ahead, Mr. McKinney.
Thank you, Your Honor. After a dispute between Mr. Brackman and Avery wrote on his car with a marker.
Yeah, Avery wrote worst attorney award in permanent marker on his Porsche.
Did Coach Brackman press charges of vandalism against her?
Objection,
He's not.
speculation. I mean, lack of foundation, which goes to speculation.
Okay, hold on. Again, the mechanical difficulties that I'm having make it very difficult for me to understand what you are objecting to. What I have heard is a question as to whether the defendant wrote worst coach ever on the decedent's car, and Mr. Cifuentes was starting to say yes, and that's all I heard. So if there's something else that you're objecting to, Mr. Holtzinger, I don't know what it is.
Your Honor, opposing counsel asked whether or not Mr. Brackman pressed charges for the vandalism on his car, and I am saying there's lack of foundation for Mr. Cifuentes to have personal knowledge as to that fact.
Well, if he doesn't know, isn't that his answer? I don't see how that's objectionable. Go ahead and ask the question, Mr. McKinney.
Did Coach Brackman press charges of vandalism against Avery Becker?
He did not.
But it was you who wished he did.
I did not.
Objection, Your Honor, relevance.
If I may respond, sorry.
Mr. McKinney, I'm having a lot of trouble because of the mechanical problems here. But from what I understand, there was a question by you as to whether the witness wanted charges pressed, and Mr. Holtzinger is objecting to that question. Is that right?
I do not believe. Oh, sorry. Go ahead. You can elaborate, co-counsel.
Sorry. Basis of your objection, Mr. Holtzinger?
Your Honor, under Rule 401, evidence is relevant if it tends to make a fact of consequence more or less probable, and the question of whether or not Mr. Cifuentes wanted Mr. Brackman to press charges doesn't make any fact of consequence more or less probable, so it is irrelevant.
All right, Mr. McKinney, do you have a response to that?
Yes, Your Honor. I hope it's not my internet, but this actually goes to a witness's credibility under 608A. A witness's credibility may be attacked or supported by testimony about the witness's reputation or character, or truthfulness or untruthfulness. Any party can criticize someone's truthfulness.
Mr. Holtzinger, I agree with Mr. McKinney to the extent that if the question is to show some kind of bias on the part of the witness, that's always fair game. If he has some reason to shade his testimony, then that's fair game. So overruled. Go ahead, Mr. McKinney.
I'll restate the question. You wished Coach Brackman press charges of vandalism against Avery Becker.
I was shocked he didn't.
After she was kicked off, your best friend reached out to you for getting help back on the team.
Yeah, actually, Avery wanted me to help her get back on the team, but there was no way that Mr. Brackman was going to let her back on the team after she vandalized his car.
It was you who didn't even want her back, though, at all.
I wouldn't really say that. Like, I wanted my best friend on the team, but she never came prepared for anything.
Well, the relationship with you and Avery might be a little unclear, but you definitely cared a lot about Coach Brackman.
Oh, I loved Coach Brackman. He was one of the best coaches ever.
As you said, he's not only a great coach, but was he also a person you really cared about?
Yes.
So when Avery apparently texted you a plan to trash his house, you must have warned the police, seeing as you cared for Brackman so much.
Actually, when she sent those text messages, I didn't really think she was going to go through that plan.
Maybe not the police, but you must have at least warned Coach Brackman, seeing as she vandalized his car.
No, I didn't think she was going to go trash his house. Like I said, she's such a sweet, innocent person. I can never see her doing that.
You just testified that Avery's a sweet, innocent person?
She's a sweet person, and she's innocent. She doesn't really think about bad things. You know what I mean?
Exactly. Looking closely at these texts in Exhibit 14, is Avery's phone number shown anywhere in these texts?
Objection relevance.
Mr. McKinney?
Yes, this was brought up in the direct, the authenticity of the text messages, and this was determined by the court that it could be brought up through cross.
Okay, Mr. Holzinger?
Your Honor, I don't believe that this specific detail about cell phone numbers being on the screen goes to the admissibility of this exhibit, especially since we don't have an actual cell phone to compare these screenshots to. So,
Holzinger, we're way past admissibility. It's admitted. And at this point, Mr. McKinney is on a project to try to undermine its credibility, and he can do that. So overruled. Go ahead, Mr. McKinney.
I'll repeat the question. Is Avery's phone number shown anywhere in these texts in Exhibit 14?
Could you pull that up?
I do not have that. It was constructively published as well as already presented by your counsel.
Okay, can I grab that real quick?
Oh, for sure, definitely. No problem.
Here it is. I do not see your phone number anywhere on here.
Are there any timestamps showing when they were sent?
There's a time. It's actually 3:23 up there, the top left corner.
No, not the time on your phone. The time when the messages were sent.
It doesn't appear there's that anywhere.
Despite this, the police saw these texts as important and wanted them.
Yeah, of course, to one of the texts.
And when you attended the police interview, as you mentioned in your direct, you wanted to help solve, you wanted to find the truth. You wanted the best for Coach Brackman.
Oh, yes, I wanted to find the truth.
So you brought your phone, which had the text confession, which the police wanted, to the police interview.
Oh, no, actually, let me tell you. We were getting ready to go to the interview.
I'm just simply asking if you bring the phone?
I think you told me that I did bring it.
I'm asking, did you bring your phone?
Oh, did I bring my phone to the interview? I did not. I forgot on the charger. It was a rush to get out.
And so it wasn't missing?
My phone wasn't missing? Oh, no, it was not missing.
So you left your phone at home during the interview, which was supposed to get to the bottom of your coach's murder.
Yeah, like I said, we were in a rush to get out, and my dad hollered at me, and I forgot it, left it on the charger, actually, because I left it in a different room to charge.
You didn't even bring a piece of potential evidence to help solve the case.
No, I had the screenshots that I had.
Do you have the phone with the confession now?
Do I have the phone?
Do you have the phone still?
Oh, no, the battery on it was just awful, so I had to get rid of it and get a new one.
No further questions, Your Honor.
All right, thank you. Mr. Holzinger, do you have any redirect within the scope of the cross?
I believe that due to the amount of time remaining, I'm not going to have a redirect.
All right, thank you. Then the witness is excused. And Mr. McKinney, you don't have to worry about the source of the technical problems. Nobody's going to hold that against you, and we have no way of knowing what the source is. So relax.
Thank you, Your Honor.
All right, scorekeepers, please complete your score sheet and let me know when you're done.
I'm done, Your Honor.
I'm finished, Your Honor.
Thank you.
I'm finished too, Your Honor.
Thank you. Okay. Prosecution, do you have another witness?
Yes, Your Honor. The people of the state of Colorado call Detective Jordan Markowitz.
Ms. Markowitz, I remind you, you remain under the oath you took at the beginning of this session. Go ahead, Ms. Kidder.
Your Honor, before I begin, may I ask how much time I have remaining?
Yes.
I have 6 minutes, 51 seconds on my clock.
Please introduce yourself to the jury.
My name is Jordan Markowitz, and my last name is spelled Markowitz.
What do you do for a living?
I'm a homicide detective with the Denver Police Department.
How long have you been with the Denver Police Department?
With the department for 13 years, but as a detective for 7.
Let's talk about some of your qualifications. Besides all the training and certification you received as a police officer, do you have any specialized training that you use in your detective work?
Yes, I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. I had to complete a 3-day training course and pass a certification test. I also had to learn to download the contents of a cell phone, as well as how to acquire and interpret cellular data and records.
And just wrap up your qualifications here, Detective. Did you have any involvement in this case today?
Yes, ma'am. I was the lead detective.
Your Honor, the people of the state of Colorado offered Detective Jordan Markowitz as an expert witness in criminal investigations with a subspecialty in cell phone technology.
Ms. Damian, do you have any objection to the admission or the acceptance of Detective Markowitz as an expert in the fields of crime scene investigation and cell phone technology?
Yes, I do, Your Honor. And may I have permission to perform a voir dire?
Yes, you may.
Thank you, Your Honor. Good afternoon, Detective Markowitz. You did a 3-day training in cell phone technology and forensic data recovery?
Yes, that is correct. I learned about different types of cell phone data, records, how to use forensic software, things to that effect.
But you don't have any other training in cell phone technology or forensic data recovery?
I've downloaded the contents of hundreds of cell phones, and I've obtained and interpreted cell tower data in over 50 cases.
Detective, I asked if you had any other training, not any other experience.
Oh, excuse me, that was my bad then. 3 days was all that I needed to complete to learn everything that I needed in this field. So I don't have any other training besides the extensive 3-day course that I took.
But you don't have a degree in forensic data recovery?
No, I don't have a degree in that.
You don't have a degree in cellular electronics either?
No, that is correct.
And you've never had an update on this course that you took?
The 3-day training course was all that I needed, and there was no need to update it because I'm constantly using what I've learned in that course.
But you never had an update, Detective, is that correct?
There was no need for one. So to answer your question more directly, it would be no.
Thank you, Detective. Your Honor, forensic data recovery is a highly technical area of expertise. And based on the fact that Detective Markowitz obtained her certification from a 3-day course alone, the defense would like to object to the certification as an expert in cell phone forensics.
Ms. Kidder?
Your Honor, we are not attempting to offer Detective Markowitz as an expert in cell phone forensics, but rather in cell phone technology. Detective Markowitz has already testified to her training, education, experience, and knowledge in this area, and therefore under Rule 702, she is qualified to be an expert in this area.
Okay, I think that there's been an adequate predicate laid for the witness's training and experience in crime scene reconstruction and cell phone technology as opposed to forensics. I would also point out, however, that from my understanding of her witness statement, she has been admitted as an expert in several cases in not only state but federal court, which is, I recommend to you, something that judges weigh carefully and take seriously, and is something that is going to get yourself a leg up pretty fast in getting your witness accepted as an expert. So, objection overruled. Go ahead.
Please explain to the jury your involvement in this case.
On Friday, March 6, 2020, we got a call about someone who appeared to be passed out on their front porch. We sent some medics, but upon arriving, they found the victim to be deceased. That's when I was called to the scene.
When you arrived, what did you observe?
I saw the front door was wide open, as well as the victim laying face down just inside the house in a pool of blood. There's blood spatter on the walls, as well as a large bloody knife just next to the body.
Please turn to what have been marked as Exhibits 1 and 3, which my co-counsel should publish on the screen for us. Do you recognize Exhibits 1 and 3?
Yes, I do.
What are they?
They are pictures of the victim's body.
How do you know?
I observed this body at the crime scene.
Are Exhibits 1 and 3 fair and accurate depictions of the victim's body?
Yes.
Your Honor, the prosecution offers Exhibits 1 and 3 into evidence.
Ms. Damiana, do you have an objection to 1 and 3?
No, Your Honor.
And 1 and 3 are admitted.
Detective Markowitz, please describe these exhibits to the jury.
As you can see, Exhibit 3 is a close-up of the victim's back and stab wound. Exhibit 1 is a photo of the victim's body as viewed from the front porch, and you could see the Ring doorbell in the top right portion of this picture, and Investigator Cusack has discussed the videos we've collected from that.
Did you do anything else to investigate this crime?
I downloaded the contents of Mr. Brackman's cell phone. That's when I found a tremendous number of texts and emails associated with the Colorado High School mock trial team. I then contacted one of the team members, Alex Cifuentes, and got the biggest break in the case.
What do you mean the biggest break in the case?
Well, Mr. Cifuentes had given me the text messages that we saw in Exhibit 14. In them, the defendant confessed that it was her intent to break in and trash.
Objection, Your Honor.
Yes.
This is cumulative evidence. I believe that the text messages speak for themselves, and what this witness is testifying to can be seen in those text messages if the jury looks at them.
Ms. Kidder?
Your Honor, this witness is trying to establish for the jury why she considered this to be the biggest break in the case, and this was also a step in forming her conclusion, which she will later testify about.
We haven't seen copies of these text messages, have we?
Yes, we have. Those were previously admitted, Your Honor.
Do you have any response, Ms. Damiana?
Yes, I do, Your Honor. I don't think that the contents of the text messages completely show the biggest break in the case. I think that rather they go to the content.
Well, I think that the text messages themselves were for the witness something that focused her attention on some aspect of the case, and that's all she's testifying to. So the objection is overruled. Go ahead, Ms. Kidder.
What did you do after seeing these messages where the defendant confessed their intent?
Avery Becker became the focus of the investigation because of 1, her expressed intention to break into Mr. Brackman's house, 2, her previous conflicts with Brackman, and 3, her prior criminal conduct in vandalizing Brackman's car.
Did you obtain—
Objection, Your Honor.
Yes, nature of your exact.
I think this witness doesn't have the knowledge yet, or the foundation hasn't been laid that they have knowledge of the things that she is pointing out as to Avery Becker's criminal activity, or that she sent those messages.
Ms. Kidder.
Your Honor, this witness has testified that she conducted a full investigation of this case. These are things that she discovered over the course of her investigation and is discussing as part of her conclusion.
Ms. Damian, what is the nature of your objection to this witness testifying to her conclusions based on the investigation that she did?
Your Honor, I believe that the proper foundation hasn't been yet laid for the jury as to the extent of Markowitz's investigation. I believe that she did testify to looking at those text messages, but she didn't entirely explain the rest of her investigation. Therefore, I think it is a lack of personal knowledge, as those things haven't been established yet.
Well, I'm not sure that an expert witness has to have personal knowledge of all of the things that she is testifying to. And while I agree that the testimony that she's given is pretty elliptical, that we don't know, and it's not very persuasive as to how she knows these things. Nevertheless, those are her conclusions. And if you want to point that out on cross, you may certainly do that. So overruled. Go ahead, Ms. Kidder.
Did you obtain any records from the defendant's cell phone?
I obtained call detail records, or CDRs. CDRs can tell you exactly when and where a cell phone reaches out to a specific tower to send or receive a text or call. So with this information, I was able to see the towers that the defendant's phone was connecting to on the day of the murder. This allowed me to conclude that her phone was near Brackman's house that day, and I've created a map that shows this.
Based on these CDRs, did you reach any conclusion as to the defendant's movements on the day of the murder?
Yes, the defendant was at home somewhere between 12:45 and 12:50 p.m., then left and drove towards Brackman's house, traveling most likely along Rock Creek Parkway at 12:55 p.m. Then from 1:05 p.m. to 1:17 p.m., Becker was at Brackman's house.
Detective Markowitz, based off of all the evidence you collected, did you reach any conclusion as to what happened in Mr. Brackman's home that day?
The defendant went to the victim's house on March 6, 2020. She broke into the home to vandalize it and was discovered by the homeowner, Mr. Brackman. Mr. Brackman had attempted to use force against the defendant, but he was killed in the struggle.
Objection, Your Honor. I believe that this witness is testifying to the ultimate conclusion. As under Rule 70B, this is inadmissible, as they are testifying to the mental state of the defendant, whether or not they would vandalize that home.
Ms. Kidder.
Your Honor, this witness is not testifying to whether or not she believes the defendant would vandalize the home. She is testifying that the defendant was vandalizing the home, but Mr. Brackman surprised them. She is basing this on all the evidence she collected, and she's not speculating. She is telling us what the evidence pointed her to and what actually happened in this investigation.
Well, under Rule 704A, it is not objectionable, not automatically objectionable, for an opinion by an expert to be excluded just because it embraces the ultimate issue of the case. And obviously that's what she's doing right now. I don't hear anything in this from what she has testified so far as to the defendant has a mental state or condition. So I'm going to overrule the objection. Go ahead, Ms. Kidder.
Finally, Detective, the defendant is not charged with premeditated murder in this case. Why is that?
Well, it was the middle of a workday pre-COVID, so it's logical for the defendant to assume that Mr. Brackman was not at home, but at work because she knew Brackman was a lawyer. I don't believe the defendant would have entered the home if she knew Mr. Brackman was inside, and she may have even tried to flee when she saw Brackman with a knife. However, a struggle did occur, and Mr. Brackman was murdered.
Thank you, Detective. I have no more questions, Your Honor.
All right, thank you. Ms. Damiano, you have cross-examination.
Yes, Your Honor. Good afternoon again, Detective. Upon your initial investigation into Mackenzie Brackman's death, you found that Brackman was involved as the coach of the CHS mock trial team?
When I downloaded the contents of the phone, there were a tremendous number of texts and emails associated with the Colorado High School mock trial team. So that is how I found out that he was the coach, yes.
And at first, you thought it seemed highly unlikely that Brackman's activity with the mock trial team had anything to do with his death?
When I first learned that Brackman was a coach, that was the first thought that popped into my head. But upon further investigation, it was absolutely clear with all the evidence that I had that Avery Becker committed this crime, which would in fact be the mock trial team.
Thank you, Detective. However, you investigated this lead and called one of the members, Alex Cifuentes.
Yes, that is correct. I did call Alex.
But Cifuentes was the only member that you spoke to on the mock trial team.
Well, he had given me the biggest break in the case. Once I had my big break, I didn't really need to speak to a whole lot of other people.
Regardless, he was the only member that you spoke to?
Yes, because he had given me the big break, and that's all that I really needed.
But you never spoke with Taylor Perkins?
I had other people in my investigation speak with her. We did have police actually speak with Miss Perkins, but I did not personally speak with Miss Perkins.
And you did not personally speak to any of the other 9 members of the mock trial team?
No, I had tried to speak to Miss Becker, who was still on the team, but she had refused to meet with me.
And you never spoke to her, is that correct?
She refused. I could not get an interview with her. She would not allow me to speak with her.
Now, one of your other initial theories, Detective, led you to believe that Mr. Brackman could have been murdered by a former client?
I'm sorry, could you repeat the question? I'm confused.
One of your other initial theories when you were looking for your quote-unquote big break led you to believe that Mr. Brackman could have been murdered by a former client.
When I first saw the victim was Mr. Brackman, I thought that it was possible to be a disgruntled ex-client, but upon further investigation, that was highly unlikely.
And you reviewed the evidence in this case, including your colleague's evidence?
Yes, I've reviewed all the evidence in the case today.
And you were aware of a student named Blair Rollins?
Yes, I'm aware of Blair Rollins as I've marked them on my CDR spreadsheet.
But you never spoke with Blair Rollins?
No, they are unlocated right now. There would be no way to speak with them currently.
So you never checked his attendance records on the day of the murder?
I personally did not. With all the evidence pointing to Miss Becker, it did not seem necessary.
And you never investigated into any other former clients of Mr. Brackman, is that correct?
I did not need to with all the evidence pointing to Miss Becker. I already had who I needed
Thank
to
you,
convict.
Detective. And you never went to Brackman's office to examine his files either?
I never went to his office, no.
You never even got a list of people that Mr. Brackman represented?
I did not need to because all the evidence clearly indicated that Miss Becker had committed this crime.
Whether or not that's true, Detective, moving into your area of expertise concerning cell phones, you are aware that a cell phone will not always connect to the nearest tower.
It's abnormal for that to happen.
But you are aware that it will not always connect to the nearest tower.
Not always, but like I said, that is abnormal. So I wouldn't base my conclusions off of possibilities or what could be's, but rather the facts that I have.
So just to clarify, Detective, even if a cell phone is far from a tower, it may still connect with it.
It's possible, but it truly is abnormal. That doesn't happen on a regular basis.
So even if Avery Becker's phone was far from a cell phone tower, there is a possibility her phone could have still connected to it. Is that true?
Well, you keep saying far, but it's only within 6 to 7 miles, which I wouldn't consider that far. So it is true, but again, abnormal.
Now, you concluded that a number of calls were placed by Taylor Perkins on March 6th. Is that correct?
Yes, that is what the CDR showed.
But you never investigated the call records of Taylor Perkins?
I did not investigate as where Miss Perkins' phone was on the day of the murder.
Now, shifting focus, Detective, you received screenshots of a text conversation from Alex Cifuentes?
Yes, that is correct.
You never took out a search warrant for Cifuentes' phone yourself?
I did not need to because I had the screenshots, which was all that I needed from his phone.
And despite having those screenshots, you never even looked at Cifuentes' phone yourself?
Like I said, it wasn't necessary because the screenshots were all that I needed off of his phone, and I already had those.
You never even got Cifuentes' phone records?
I did not get his records because those records would have no bearing on my investigation. I only needed the screenshots.
Now, the only evidence you have of these text messages are screenshots, yes or no?
It would depend on what you define as evidence.
It's a yes or no question. The only evidence you have of these text messages are the screenshots.
Well, then I would need you to clarify, please.
You don't have a phone to look at the screenshots with, is that correct?
Mr. Cifuentes had forgotten to bring his phone with him to the interview, so I did not see them on his phone specifically, but I had the screenshots.
And these screenshots were sent to you by Cifuentes himself?
Yes, that would be correct since they were on his phone.
They do not show the date of the text messages.
They do not, but they do clearly say that it's Avery with the contact name, and Avery identifies herself in the text messages.
But there's no phone number connected to Avery Becker, is that correct?
Well, it is an iPhone, so I cannot, with just the screenshots that I have, you will not be able to see the phone number that's associated because that is not how the layout of an iPhone is.
Thank you, Your Honor. I have no further questions for this witness.
All right, thank you. Ms. Kidder, I don't know what time you have left. It's not much, but you have redirect.
Can I ask how much time I have left, timekeeper?
Yes.
Yes, you have 1 minute, 26 seconds remaining.
Detective Markowitz, opposing counsel alleged that you only looked for what evidence you wanted. Is that true?
No, I looked at the evidence and followed it where it took me, as any good investigator would.
And were you able to tell whether or not those screenshots were accurate representations of the conversation?
As a detective, I can tell if evidence was doctored. That's part of my training in police academy. So I would not have relied on these text messages if they were, excuse me. And there's no evidence to support the theory of those text messages being doctored.
Thank you, Detective. I have no more questions, Your Honor.
All right, Ms. Damiana, I don't know if you have any time left. Do you have any recross within the scope of the redirect?
I do not, Your Honor. Thank you.
All right, thank you. Then the witness is excused. And the scorekeepers may mark their cards. Let me know when you're done.
I'm finished, Your Honor.
Thank you.
I'm finished as well, Your Honor.
Thank you.
I'm finished, Your Honor.
All right, thank you. Does the prosecution have any additional witnesses?
The prosecution rests, Your Honor.
Thank you. The defense may call its witnesses if it chooses to do so.
Yes, Your Honor. The defense would like to call Avery Becker to the stand.
All right, Ms. Becker, I remind you remain under the oath that you took at the beginning of these proceedings.
Yes, Your Honor.
Good afternoon, Ms. Becker. Would you please state your name and spell your last for the record?
My name is Avery Becker. Becker is spelled B-E-C-K-E-R.
Fantastic. And how old are you, Ms. Becker?
I'm 18 years old. I graduated from Colorado High School last year.
How do you know the late Mackenzie Brackman?
Mr. Brackman was my mock trial coach during my time at CHS on the mock trial team.
And how long were you on the mock trial team there?
I participated for all 4 years of high school.
That's a long time, Ms. Becker. Why did you join?
Well, I originally joined because I wanted to hang out with my friend Taylor Perkins and play on our phones. But after a while, I developed a real passion for the activity. I really enjoyed mock trial.
Now, from your own perspective, Ms. Becker, what did your relationship look like with the late Coach Brackman?
Mr. Brackman and I had a lot of conflict during my time in mock trial. I mean, we just didn't see eye to eye on a lot of things. And so we got into arguments.
And despite those arguments, were you proud of your accomplishments on the team?
I mean, I thought we were a great team, and I thought that I had some really good contributions to the team. Yeah, I was very proud of us.
But were you ever demoted to the B team?
Unfortunately, I was demoted to the B team.
When did that happen?
Shortly before regionals in my senior year, Coach Brackman and I got into a bit of an argument, and he unfortunately demoted me from the A team to the B team.
Did you ever regain your position on the A team?
Yeah, so my best friend, Taylor Perkins, who I believe is here today as well, generously decided to quit the A team in order to let me regain my position because he thought it would be best for the team.
And were you proud of how you performed at the regional tournament?
Yeah, I mean, I thought we did great, and we won, so that was pretty exciting as well.
But how are you received by Mr. Brackman and the rest of your team?
Well, Mr. Brackman kind of appeared to be pretty angry with me at that practice, and we ended up in an argument.
How did that argument affect you?
I mean, I was pretty angry. I was really proud of the way that our team had performed and the way that I had performed, and I felt like Brackman was kind of insulting me and insulting us.
What did you do in response to that?
Well, unfortunately, I made the extremely irresponsible decision to storm out of practice and write Worst Attorney Award on Brackman's car. You know, in hindsight, that was an extremely misguided decision that I now regret. And it was completely unjustified.
And from your own perspective, how did Mr. Brackman respond to that incident?
I mean, Mr. Brackman was very reasonably angry at me. I had written on his car and he was mad. So he kicked me off of the mock trial team altogether.
How did you feel after that incident?
I was pretty angry still after the incident. I felt like, the argument wasn't justified. And so I was still pretty angry, honestly.
Did you ever apologize to Mr. Brackman?
Yeah, so I pretty quickly realized that what I had done was really awful, and determined that it was going to be important for me to apologize as soon as I could.
How long after did you apologize?
I mean, I went to his office the next day. I waited a couple of hours to sort of cool off, but I went to his office in an attempt to apologize the day after.
How were you received when you went to his office?
Well, his secretary wouldn't let me in. And so in response, I decided I would send a text message of apology to Brackman, where I offered to also pay for his car, which I had damaged.
Did Mr. Brackman ever respond to this text?
No, he did not. I would imagine that he was probably killed before he responded to it. So, no, I never received a response.
And Ms. Becker, at the time of your coach's death, did you still feel guilty about his car?
Oh, of course. I mean, I still feel guilty about that. It was such a bad decision, really. So yeah, I definitely felt even really more guilty at the time.
And briefly, what happened on March 5th, the day before Mr. Brackman's murder?
Taylor Perkins and I spent the evening hanging out at the Fry Shack in the mall.
Did you lose your phone during that time?
Yeah, so I did not realize at the time, but it appears since then that I misplaced my phone somewhere that evening.
Were you ever able to retrieve your phone?
No, I was never able to find it.
Are you aware of any calls made to that phone on March 6th?
Yeah, so on March 6th, Taylor and I spent the day looking for the phone, and the way we decided we were going to look for it was to call it a bunch of times to see if it would make a noise while we were looking around, sort of retracing our steps.
Did you ever intend to go near Mr. Brackman's house during that day?
I mean, aside from the fact that I didn't know where Mr. Brackman's house was, I had no reason to go there. I didn't want to show up there since I was, still trying to get back on the mock trial team, and it might seem to him like I was trying to vandalize his car again or something.
Now, switching topics, Ms. Becker, would you consider yourself close to Alex Cifuentes?
Not really. I mean, Alex was on the mock trial team, but I never knew him that well.
And And would you have sent the text messages in Exhibit 14 to Alex Cifuentes?
No, I mean, Alex is kind of the last person I'd ask for help on anything, honestly, so it wouldn't have made sense for me to do so. Aside from the fact that it would be horrible to trash Mr. Brackman's house immediately after already having damaged his property.
And Ms. Becker, is it true that you plan to trash Mr. Brackman's house?
Of course not. Again, aside from that being horrible, I was still felt extremely guilty for having damaged his property.
Were you responsible then, Ms. Becker, and I hate to ask this, for the murder of Mackenzie Brackman on March 6th of 2020?
Certainly not. Mr. Brackman and I had conflict, but I never would have wished this upon him, and I really regret that it happened.
Thank you, Your Honor. I have no further questions for this witness at this time.
All right, thank you. Ms. Nguyen, do you have cross-examination?
Yes, Your Honor.
Go ahead.
All right, good evening, Ms. Becker. I also have a couple of questions for you. First, about your relationship with Mr. Brackman. In your own words, you hated him, right?
Sometimes I definitely felt that way. I think that we had a lot of conflict in our relationship, and it was pretty challenging to get along with him sometimes.
But those were your words, that you hated him, right?
I think I probably would have said that at some points.
And it's also your words that Mr. Brackman hated you as well, right?
I definitely felt that way sometimes. It was pretty challenging to work with him as a coach, since he didn't seem to appreciate the things that I brought to his team.
Let's discuss some of the reasons for this mutual hatred. First, you previously said that Mr. Brackman always criticized you, right?
I mean, I think that we just disagreed on how it was best to prepare for mock trial. I mean, yeah, he criticized me a lot.
And you've also said that his role was simply to attack you, right?
I mean, I would say that more about witnesses in my time as an attorney in mock trial, but I suppose that you could also apply that to Brackman. I mean, there were times when I definitely felt like that.
I mean, Brackman would go nuts when you didn't do what he wanted, right?
As I said, we had a lot of disagreement.
I mean, you argued with him at almost every practice. Isn't that true?
That is true.
And you've also said that Mr. Brackman always unfairly accused you, correct?
I definitely thought that he didn't appreciate my talents and that he didn't appreciate the things that I brought to his team.
I mean, Mr. Brackman always called you lazy, right?
Yeah, he did call me that sometimes.
Objection, Your Honor. Hearsay. This is an out-of-court statement by Mr. Brackman.
Ms. Nguyen?
Yes, Your Honor, this is not being offered for the truth of the matter, but rather for the effect on the listener and how it made Ms. Becker feel about her relationship towards Mr. Brackman, and therefore it is not hearsay.
Ms. Damiana?
Your Honor, I stand by my objection that this is an out-of-court statement regardless.
All right, it is an out-of-court statement. I don't see how it's being offered for the truth of the matter asserted. The decedent called Ms. Becker lazy, and whether that's true or not is not really pertinent to the question. So go ahead, overruled. Ms. Nguyen.
So just to be absolutely clear, just yes or no answer, Ms. Becker, Mr. Brackman would always call you lazy, right?
Called me that.
And Mr. Brackman didn't just criticize you privately, he did it in front of the whole team, right?
Yeah, he did sometimes.
And in addition to these bad feelings about one another, several times your relationship went farther than just words, right?
I mean, again, we had conflict, Mr. Brackman and I. We argued,
For example, Ms. Becker, during the regional tournament of 2020, he demoted you from the A team to the B team, right?
Yeah, he did.
And then when you went to regionals and won an award, Mr. Brackman criticized you and you called him the worst coach in the state, right?
Unfairly. Unfortunately,
But then,
I would say that.
Then, Miss Becker, you took some sort of marker and drew worst attorney award on the hood of his car, right?
It was extremely irresponsible. Mr. Brackman and I, we didn't get along, but he was a coach who got us to a competitive level.
But Miss Becker, you know that an act like that is a crime, right?
I am aware of that.
Objection, Your Honor. I believe that this is improper character evidence. I think that this is being used to prove that Ms. Becker may act in accordance with this character trait in another situation.
Ms. Nguyen?
Your Honor, under the rules, improper character evidence is that as an objection to the evidence or character proof is limited. I don't see how this is improper character evidence, since I'm simply asking Ms. Becker if she knew what she did was wrong, and she seems to agree with that.
Well, I agree that the question, which is whether the witness knows that vandalizing a car is a crime, is not a question meant to elicit anything about her character or much about her character. It is just the state of her knowledge. So I will overrule the objection. Go ahead, Ms. Nguyen.
I'm going to continue, Ms. Becker, for the sake of time. When Mr. Brackman saw what you had done, he exploded and kicked you off the team, right?
Yes, he did.
And on that occasion, using your own words, he yelled, "What the hell have you done to my car? That's it. I've had enough of your crap. You don't work, you screw around in practice and are disruptive. You talk behind my back, and now this. I have had it. You are off the team." Those were his words, right?
That is what Mr. Brackman said to me.
And in your own words, that made you even madder than getting criticized in front of the team, right?
Yeah, at the time, I was definitely quite upset.
And immediately after you got kicked off the team, you went home and told your own mother that Mr. Brackman got mad at you for no good reason. Isn't that true?
In a lie that I now regret, and it didn't honestly make that much sense to tell. I did tell her that.
But just to be perfectly clear, Miss Becker, you didn't tell your mother the truth, right?
It was a lie, and I regret that.
But you did tell your mother, and I quote, that you would get back at Mr. Brackman if it was the last thing you did. Those were your words, right?
Those were my words, and I definitely think that in hindsight, that was really regrettable. I wish that Mr. Brackman was still alive.
Miss Becker, I have no further questions, Your Honor.
All right, thank you. Ms. Damiana, do you have any redirect within the scope of the cross?
Yes, Your Honor, I do.
Go ahead.
Ms. Becker, would you call your relationship with Mackenzie Brackman aggressive?
I mean, we certainly had disagreements and we certainly had conflict, but not to the point where I would have, felt the need to be violent towards him.
And after the incident involving his car, how long did it take you to apologize?
I mean, I realized within hours that what I had done was extremely wrong. I went home and after cooling off very briefly, I realized that I had made an extremely irresponsible and misguided decision.
Do you still feel guilty about this incident?
Of course.
And would you have therefore wanted to further strain that relationship?
No, I would not have. Mr. Brackman and I had disagreements, but, it was mock trial. It wasn't, the core of my identity or anything.
Thank you, Ms. Becker. Your Honor, I have no further questions on this redirect.
Okay, Ms. Nguyen, do you have any recross within the scope of the redirect?
No, Your Honor.
Then the witness is excused. Thank you. The scoring panelists may mark their scorecards and let me know when you're done.
I'm finished, Your Honor.
Thank you.
I'm finished, Your Honor.
Thank you. Are we all done?
Can you hear me?
I can now, yes.
Yes, I am. I'm having
right.
technical difficulties. My apologies.
That's all right. Thank you. Defense, you have another witness?
Yes, Your Honor. The defense would like to call Taylor Perkins to the stand.
Mr. Perkins, I remind you that you remain under the oath you took at the beginning of these proceedings. Mr. McKinney, go ahead.
Please state your name and spell the last for the record, Mr. Perkins.
Hi there. My name is Taylor Perkins, and my last name is spelled Perkins.
That's wonderful, Mr. Perkins. How old are you?
I'm 19 years old right now.
And where did you go to high school?
Well, last year I graduated from Colorado High School, or just CHS for short.
And what is your relationship with Avery Becker?
Oh, Avery and I are best friends. You could even call us besties.
And how long has this relationship lasted?
Pretty much as long as I can even remember. Definitely a super long time.
And were you in mock trial with Avery?
Yeah, I was. Funnily enough, it was actually Avery that suggested that I join the mock trial team.
And besides mock trial, did you hang out a lot inside and outside of school?
Oh, all the time. We'd either be carpooling to and from school. We shared a lot of our classes together, and we even hang out with each other after mock trial.
And how was Avery, in your perception, as a member of mock trial?
Oh, as a member of mock trial, she was incredible. I mean, you really just had to see it, but as a member of the team, she could be a little underprepared at times.
And how did Coach Brackman react to this unpreparedness in your perception?
Brackman was never a fan of it. Whenever she'd come in prepared, he'd usually get pretty angry with her.
And was Avery ever demoted for this kind of behavior?
Yes, she was. One practice, Avery showed up the most unprepared I think I've ever seen her. I mean, it was a total train wreck, and Brackman just decided that he had enough of her, so he demoted her.
And what did you do after this?
Well, afterwards, I had to give some thought about what I wanted to do, but it wasn't a hard decision. After 3 weeks, I decided to step down from the A team so Avery could reclaim her spot.
And unpreparedness seems to be one concern for Coach Brackman, but how was Avery and Brackman's relationship as a whole from your point of view?
Objection, speculation.
McKinney?
Yes, Your Honor. This is all based on the perspective of Taylor Perkins, not commenting on the innards of this relationship, only from the perspective of this witness.
Mr. Holzinger, you have a response?
Your Honor, I believe that what opposing counsel just stated is that this is based on their perception, but that doesn't mean that it's based on observations that they actually made of actual physical actions or anything that would disqualify this testimony from being based on what's inside of their head.
Well, I don't understand the distinction between observation and perception. The question is
Your Honor,
from Mr. Perkins' perception, and that's all I'm asking. So overruled. Go ahead, Mr. McKinney.
I'll re-ask the question. Unpreparedness seems to be one concern, but how was Avery and Brackman's relationship as a whole from your point of view?
Well, I've always kind of thought that their relationship was negative. Whenever Avery would get to practice, Brackman would always be yelling at her for something. It was never good.
And did this strenuous relationship result in any serious actions?
Yes, it all resulted in what I've now dubbed as the car incident. Avery told me right after it happened, but she said that Brackman was yelling at her.
Mr. McKinney, there's a hearsay objection.
Yes, Your Honor. This is not hearsay due to going towards the state of mind rather than the truth of the matter, as well as present sense impression. This witness was not only with Avery at the time, but this does not go towards any kind of truth of the matter, only the state of the mind of the declarant.
Mr. Holzinger?
Your Honor, the statement being made by Mr. Perkins is not a present sense impression because the statement itself is in regards to the actions that happened on the night that the car was vandalized. And there are no statements being made of that night, but the knowledge that Mr. Perkins has of this is what the statement is coming from.
Well, what I heard was from the witness was what what the defendant told him. And to that extent, I don't know about present sense impression or what the status of his mind is. All I hear is hearsay, so sustained.
Yes, Your Honor. And that night after, what was Avery's reaction in your view?
Well, from that incident, she seemed really down in the dumps. I mean, she looked visibly worried and almost apologetic even. So we went out to hang out at my house, and I even decided to try to bring her spirits up. So we went to the Fry Shack to hang out.
And at this this is, what night is this event at the Fry Shack?
This was the night of the car incident, as it's been called.
That night, March 5th, was there anyone else at the Fry Shack?
Yes. Originally, it was just normal people, but after some time, some of the mockers decided to trickle in.
And what events happened with these mock trialers, or mockers, as you say?
Well, from what I could tell, everyone was super apologetic and just apologizing to Avery, except for Alex Cifuentes. In my view, Alex seems super insincere and just passive aggressive about the entire situation.
And moving on to the day of the murder, March 6th, what were you doing?
Well, I began my normal my morning like any other day. I was getting ready for school and texted Avery so that we could carpool and form a plan, but Avery just didn't respond to me.
And what did you conclude from that? What did you both conclude when you met up?
Well, we didn't conclude anything at first, but Avery ended up dropping by at my house, and we decided that she probably lost her phone the night previous.
And where was the last place you saw the phone?
Well, now that you say that, I last saw the phone in front of Alex Cifuentes on the table when Avery stormed off after Alex's insincere comments.
And where did you look for the phone?
Well, we retraced our steps from the last day. We decided to skip class and just go to the mall and look for the phone at different places we'd been.
And how did you look for the phone?
Well, we looked all over for it. And when we weren't looking, I was calling for it to see if I could hear the ringtone of the phone.
And was calling the only way to find the phone at the time?
Unfortunately not, but it was the only thing I could think to do. Avery had this Apple iPhone and I have an Android, so I didn't think you could use any other methods, but apparently using the Apple, you can use like
Objection,
a website.
Your Honor. Narrative response.
Mr. McKinney?
The question was asking, was calling the only way to find the phone? And this witness is testifying to that question only. He's not elaborating on other things, only to that question.
Mr. Holzinger?
Your Honor, this question was broad and covers a long time period, but this witness had could have answered this very briefly, but instead used, I believe, over 4 sentences, and they continued to talk. And so I objected to a narrative response that they had given to this question.
I think that he was attempting to give a complete response to the question as to how he was searching for the phone. It doesn't seem to be going on too long, so I'm going to overrule the objection. Go ahead, Mr. Perkins.
And briefly, was calling the only way to find the phone?
No, once again, Avery had an Apple iPhone, and apparently you can use this iCloud website to like locate and track it, but I never thought of it, and Avery was really nervous about not having her phone.
So on the day of Brackman's murder, March 6th, you were with Avery all day?
Yep, glued at the hip looking for her phone.
And Avery never left you for any period of time?
No, she was my ride. If she left, I would have been stranded.
And you went to the mall, the Fry Shack, but did you ever go to Coach Brackman's house?
No, no, we didn't.
And was there ever any reason to go to Coach Brackman's house?
No.
Objection, lack of foundation, which calls for speculation.
Mr. McKinney?
This witness has just testified as to the reasons why they were around town and looking for the phone. This is completely within the witness's scope of knowledge, as this is pertaining to the events of the day and reasons to do those events. So he can testify to the reason why not do something as well.
Mr. Holstinger, could you explain the basis of your objection?
I believe that the question that opposing counsel asked Mr. Perkins was would there have been any reason to go to Mr. Brackman's house? And I believe that calls for a speculation, as there's been no foundation laid as to how Mr. Perkins would have any knowledge about that.
Well, I think that the witness can testify to whether he had any reason to go to the house. And to that extent, the objection is overruled. Go ahead.
And so finally, Mr. Perkins, since Avery was with you all day and never went to Brackman's house as you were with her, did Avery ever kill Coach Brackman?
I can say with 100% that Avery never killed Brackman.
Thank you, Your Honor. Thank you, Mr. Perkins. I have no further questions.
All right, Mr. Holzinger, you have cross-examination.
Good evening, Mr. Perkins. I have a few questions for you as well. I'd like to discuss your friendship with the defendant as you testified on direct. First, like you said, you say that you were best friends with the defendant.
Oh, we're super close with one another.
And despite being best friends, you thought that the defendant could be rash and have an inflated ego, right?
Usually when she was on the mock trial team, she could definitely act that way sometimes.
And you spoke with the defendant pretty frequently, didn't you?
Oh, we hung out all the time. Once again, it was through carpooling and through school. We get to chat up with each other. And then afterwards at mock trial, we'd interact and hang out with each other afterwards.
In fact, after Mr. Brackman was murdered and you found out you were going to be a witness at trial, you and the defendant were able to get together and talk about the day of the murder. Is that correct?
I mean, sure.
Objection,
we were just trying to...
relevance. This is about the events in question, not pertaining to after.
Mr. Holzinger?
Your Honor, I asked Mr. Perkins about whether or not they were able to get together and talk with the defendant about the day of the murder afterwards. This goes to Mr. Perkins' credibility as a witness because it proves that the defendant and Mr. Perkins were able to coordinate their stories after the event. So therefore, this is extremely relevant.
Mr. McKinney?
In that case, I also object on the grounds of speculation by the counsel. There is no evidence provided so far that during any kind of meeting, which is also hearsay, that there was any kind of discussion to plan their stories together.
Well, I don't think that counsel's speculation is at issue here. The question is, if the question at all is whether the witness is speculating. So what's your objection?
Oh, sorry. My objection, the question was asking about the events where they spoke after the day of the murder. And it was an objection to relevance, as this has little relevance to the case at hand.
Well, I think that a witness's bias, coordination, credibility is always an issue that can be inquired into. And Mr. Holzinger's question, to the extent that it implies that there was some collusion between the witness and the defendant, is pertinent and proper, but it is up to the jury to make their determination based on what they hear as to whether to accept that implication from Mr. Holzinger. So overruled. Go ahead, Mr. Holzinger.
Let me repeat the question. After you found out that you were going to be a witness at trial, you were able to get together with the defendant and discuss the events on the day of the murder, right?
Oh, sure. We talked about it, yeah.
Let's talk about Mr. Brackman. The defendant did not like Mr. Brackman, did he? Sorry, she.
No, that's okay. They never really got along, no.
And you also didn't really like Mr. Brackman, did you?
I mean, I thought he could be overbearing, and I really thought he was a mediocre coach, but my feelings weren't really intense against him.
In addition to thinking he was a mediocre coach, you also thought he was a mediocre lawyer in real life, right?
I mean, you know the saying, those who do, those who can't coach.
Mr. Perkins, Mr. Brackman once demoted the defendant to the B team, correct?
Yes, that is true.
And you quit the A team after that, right?
I mean, yeah, but I had 3 weeks to think it over, and I really thought that was the best decision for me.
And after you quit the team, the defendant was put back on the A team, right?
Yeah, she was.
And you're aware that the defendant once destroyed the paint on Mr. Brackman's car?
I am aware that she wrote on his car, yeah.
And she did this because she wanted to let off steam and freak Mr. Brackman out. Is that correct?
Well, I actually don't know what Avery was thinking at the time. No.
Mr. Perkins, you wrote a witness statement for this trial, correct?
Yes, I did.
Can we turn to that witness statement now? I believe we'll have it on the screen. Mr. Perkins, on the last page of this witness statement, do you see your signature at the bottom of the page?
Yes. Oh, you're sharing it too. Yes,
Yeah,
I do.
really quickly. We'll wait until my trial technician gets it on the screen. All right, and right above your signature, read along with me. I have carefully reviewed this statement. It is true and accurate and includes everything I know of that could be relevant to the events I discussed. Did I read that correctly?
Objection. This line of questioning calls for speculation. Opposing counsel is asked to the state of mind. Whether it's in the witness statement or not doesn't change the fact that it's a speculative statement. If Avery was trying to let off steam, that is only by the intention, that is only the speculation of this witness.
Well, at this point, I'm a little bit confused because the counsel on direct objected to the testimony of this witness of whatever it was that the defendant told him about the car incident. And now he's asking about what the defendant told him about the car incident. So I'm a little confused about that, but I don't think it's speculation. At least we can't tell that at this point. So go ahead and overruled, go ahead and ask the question.
All right, Mr. Cifuentes, or sorry, my bad, Mr. Perkins, could we please turn to line 42 on page 41 of your witness statement?
My screen is blank, so am I still here right now?
Yes, you are.
I believe you are, yes.
I can continue. I have a physical copy. Please don't let this count against time. What page is that?
Page 41 and line 42.
Okay, I'm here.
All right, read along with me. Avery just wanted to let off some steam and freak Coach Brackman out. Did I read that correctly?
Yes, you did.
On the spot, after the defendant destroyed the paint on Mr. Brackman's car, Mr. Brackman kicked the defendant off the team, right?
Yeah, he did.
And because this was the defendant's senior year, that means she lost her last opportunity to be on the team, right?
Yeah.
Let's discuss your story about the day of the murder. You have stated that Ms. Becker is so connected to her cell phone that it is like her third kidney. It was never out of her reach, right?
Oh, that thing never left her side. She was infatuated with her phone. She was usually on it all the time.
Despite your testimony that she was infatuated with your cell phone, it is also your testimony that she left the fry shack for whatever reason without her cell phone, correct?
I mean, she left after Alex Cifuentes had really bothered her. She was really upset about it, and she just stormed off.
After she left the fry shack without her cell phone, she also spent the entire evening without her cell phone, correct?
Yes, that is correct.
And despite the fact she was so attached to it, she also spent the entire morning of the murder without her cell phone, right?
Yeah, at least I think so, yeah.
And only after she picked you up to go to school, only then did both of you realize that she did not have her cell phone, despite the fact she was so attached, correct?
Well, that's the only time I could have realized. I mean, she wasn't responding to my text, so I guess that's when we both thought that she had lost it.
No more questions, Your Honor.
All right, thank you. Mr. McKinney, do you have any redirect within the scope of the cross?
Yes, Your Honor, briefly. Mr. Perkins, sorry, just a bit distractions right now in my house. All right, sorry, say it again. Mr. Perkins, when you stepped down on the team for Avery Becker, did you do it for the team or for Avery?
I mean, I did it for the team. I mean, even though I was best friends with Avery, I knew the team could never go on without her. So it was also for Avery too.
And you get no further questions, Your Honor.
All right, Mr. Holtzinger, do you have any recross within that very short redirect?
No redirect, Your Honor. Or sorry, recross, Your Honor.
All right, thank you. Then the witness is excused.
If I may ask a question really quickly, would the coordinator be able to mute my microphone as my screen is black? Thank you.
I'm going to try. Let me see.
All right. While we're doing that, with the scoring panelists complete their sheets and then let me know when that's done.
Finish scoring, Your Honor.
The only option I have is to
I'm
ask.
finished.
Unmute. Okay, let's see if I can do that.
I'm finished, Your Honor.
All right, thank you. It appears that Mr. Perkins' microphone is muted, so we're all set.
Dylan, did Dylan want me to unmute his?
No, he wants it muted, so we're all set.
Thank you.
Thank you. Okay, defense, next witness.
Your Honor, the defense calls Professor Blake Van Owen to the stand. In addition, if you would be able to turn off the camera for Dylan Schneider, that would be useful as well, but it's understandable if you're not able to do that.
Mr. Perkins, can you turn off your camera? No, you cannot. Maureen, can you turn off his camera?
I'm going to try.
Mr. Perkins, I'd suggest that you turn around and face the curtain, but I'd just be kidding.
All I can do is ask him to do it, and he can't do it.
And he can't do it, so we'll have to look at his lovely face. That's not going to hurt us at all. Professor Van Owen, I remind you that you remain under the oath you took at the beginning of these proceedings.
Thank you.
Mr. Littlewood, you may proceed.
May I request the time check?
Yes.
You have 9 minutes, 45 second clock.
Thank you. Could you please state your full name and spell the last for the record?
Yes, my name is Blake Van Owen, last name spelled V-A-N-O-W-E-N.
And would you tell the jury your connection to this case?
Yes, I'm a private investigator who's been consulted by the defense to do some extra work in investigating who truly committed this terrible crime.
How did your career in law enforcement begin?
I worked as a police officer for the Aurora Police Department briefly until I left for a variety of other professions.
Why did you leave the Aurora Police Department?
There was a certain incident in which a detainee of mine was injured, and after reaching a settlement, I realized that the intrinsic issues within the Aurora Police Department were not worth me staying, and thus I pursued other ventures such as teaching and community police work.
Were you fully cleared of any wrongdoing from that incident?
I was, yes.
What did you do after leaving the police department?
I started teaching courses at a community college. From there, I achieved a master's degree from Ashford University online and began teaching courses at CU Denver, earning me the title of Professor Van Owen.
And do you frequently appear as a witness in court?
I do, yes.
When you appear in court, what areas of expertise do you testify on?
A wide range: general police practices, cell phone tower data analysis, crime scene reconstruction, etc.
In how many states have you been accepted as an expert in district courts?
3 states, those of Colorado, Kansas, and Arizona.
And in how many states have you been accepted as an expert in state courts?
States, those of Wyoming, Nebraska, New Mexico, and Colorado.
How many times have you been accepted as an expert in crime scene reconstruction?
8 times.
How many times in cell tower analysis?
5 times.
General police investigation tactics?
12 times.
And how many total cases have you consulted in?
I'd say I've been consulted over 100.
Your Honor, I would like to qualify Professor Van Owen as an expert in crime scene reconstruction, cell tower analysis, and general police investigation tactics on the grounds of his extensive education and experience in these fields under Rule 702.
Ms. Kidder, do you have an objection?
Yes, Your Honor. We object to both the crime scene reconstruction and cell tower analysis.
On what ground?
We believe that Professor Van Owen cannot lay any foundation for having expertise in either of these areas.
Your Honor, if I may respond.
Yes, you may.
Professor Van Owen has already testified as to his extensive education in investigation tactics, such as those that have been objected to, and in addition has presented evidence that he has been accepted as an expert in those fields in numerous courts throughout his career, which again goes towards his experience and expertise.
Ms. Kidder?
Your Honor, while it is true that Professor Van Owen has been accepted as an expert before, under Rule 702, experts can only be admitted via means of knowledge, skill, experience, training, or education. While Professor Van Owen can testify to previous testimony, that is not one of these criteria, and he cannot testify to any knowledge, experience, training, skill, or education, given the facts of this case.
Your Honor, if I may respond.
Yes, this is a very abstract argument. And I guess I would like to have it engaged on the basis of what Professor Van Owen knows or doesn't know, what his experience is or is not. Go ahead, Mr. Littlewood.
Your Honor, I believe that the evidence regarding when he has been accepted as an expert in other courts goes to prove his expertise and experience, and therefore can serve as evidence to qualify him as an expert.
Ms. Kidder?
Your Honor, while he can testify to experience testifying about these things, he cannot testify to any specific experience he has. And given the facts of this mock trial case, that means he can't be testified. That means he can't be admitted as an expert.
Well, what specifically are you objecting to in his background?
The crime scene reconstruction and the cell tower analysis. He can't lay foundation for either of these. We have no objections to the police practices.
Mr. Littlewood?
I stand by the motion to qualify the witness as an expert. I believe that sufficient foundation has been laid for all three of the areas in which I requested him to be qualified.
Well, I think that as I said, this has been very abstract, and neither one of you has really pointed to what his experience is or is not. I think that if the basis of the objection is that his qualifications as an expert in other cases is insufficient to prove that he is an expert in this case, while in and of itself may be accurate, any court in probably any jurisdiction in the United States, when faced with a witness who has been qualified by other courts in the areas of expertise for which he's being proffered, is going to give serious concern to the actions of other courts, because that judge is going to feel protected because other judges have already made a decision and he doesn't have to make a decision again. However, I would say, Mr. Littlewood, that if the question is, what are his qualifications, then in and of itself, being admitted somewhere else isn't going to do that. If you just have some modicum of experience saying that I did this, I studied that, I was admitted in X, Y, or Z court on crime scene investigation or cell phone data, that's going to help your cause. On the basis of this record, I'm going to overrule the objection and admit Professor Van Owen on the fields of expertise of crime scene reconstruction, general police procedures, and cell phone data in analysis.
Thank you, Your Honor. Professor Van Owen, do you frequently rely on cell tower data in the course of your practices?
I do, yes.
Do you frequently review the work done by crime scene reconstructionists?
I do. In my years of working as a private investigator, I've used both on numerous occasions.
Thank you. Now, in your work on the case at hand, what police evidence did you review in forming your opinion of the case?
I reviewed the work done by Detective Markowitz, as well as the work done by Ms. Kuzak.
I'm going to ask you now about some of your specific issues with Kuzak's conclusions. What is Kuzak's theory of how the confrontation occurred between the victim and the intruder in the victim's home?
In general terms, Kuzak believes that there was an intruder who broke into Mr. Brackman's home and through a scuffle eventually stabbed Mr. Brackman.
What evidence did Kuzak use to back up this theory?
One of the foremost issues that Kuzak cites is the scuff marks located near the door, supposedly made by shoes, as well as a specific angle the knife went in.
Do you take any issue with the scuff marks?
I do, yes. Those scuff marks cannot specifically attributed to this crime. There's no way of knowing if those scuff marks originated from the perpetrator or from Mr. Brackman, or when those scuff marks even took place.
Moving on, are you aware that Brackman had Ring doorbells set up at his residence?
I am aware of this, yes.
Did the police make any investigation to determine if Brackman had push notifications on?
They did not, no.
Would this have been within their power?
It certainly would have as a police department, yes.
Now, let's move on to your evaluation of Detective Markowitz's investigation. Were you present today in the courtroom during the testimony of Taylor Perkins?
I was, yes.
Do you recall Perkins' statement that during the time of the murder, Perkins and Avery were searching for Avery's lost phone at the mall?
I did hear that, yes.
Were you aware of this fact prior to the trial today?
Yes.
Now, since Avery did not have their phone at the time of the murder, even if the cell tower data indicated that their phone was near the victim's house, would that mean that Avery was near the victim's house?
In no way does that equate. People are not inherently where their phones are. Again, if the phone was lost, then saying that the phone was located near the house in no way confirms that that person was.
Now, did the police detectives look at the cell tower data for Taylor Perkins' phone?
They did not.
Would it have been within their power to access this data?
It certainly would have, yes.
Did you view the cell tower data for Taylor Perkins' phone?
I did in my investigation, yes.
And what did this data indicate?
I corroborated the story provided by Taylor Perkins that Taylor and Avery were at the mall searching for the missing phone.
Now, in reviewing the evidence for the case, did you view the screenshots of the text messages shown in Exhibit 14?
I did.
Do you take any issue with these screenshots?
I do. Many of them were brought up earlier in this case, but just the lack of timestamps, the lack of a number identification to confirm that that in fact is Avery, and just general authenticity claims concern me as to the actual real nature of those texts.
Would it have been within the power of the police to search Cifuentes' phone to verify that these texts were actually sent from Avery?
It would have. A simple access to that phone instead of screenshots could have done.
And during your investigation as a private investigator, did you develop any other suspects for this crime?
I did. One Blair Rollins.
What was Blair Rollins' relation to Brackman?
Objection, Your Honor, speculation.
Your Honor, if I may respond.
Mr. Littlewood? Yes.
Your Honor, I'm not asking the witness to speculate as to whether they had a good relationship or a bad relationship. I am merely asking how they might be related to each other, such as how they knew each other.
Ms. Kidder?
My apologies, Your Honor, I misunderstood the question. If he is truly just asking about how they may have known each other, and this is within the scope of Professor Van Owen's personal investigation, then I withdraw my objection.
All right, thank you. Go ahead, Mr. Littlewood.
Thank you. I'll ask again, what was Blair Rollins' relation to Brackman?
Blair Rollins' father, Jonathan Rollins, was convicted of a crime with Mr. Brackman as his defense attorney.
What was the sentence given to Jonathan Rollins?
It was a life sentence.
Is Blair Rollins roughly the same build as Avery Becker?
About, yes.
Where's Blair Rollins now?
I do not know.
Have you tried to find him?
I have. In my course of investigating this, I have tried to find the location and have not succeeded.
Did the police ever try to find him?
They did not. They had an ample opportunity towards the beginning of this case when it was still new, but they did not take that chance.
Did the police ever conduct any investigations into Blair Rollins?
No, they were almost entirely focused solely on Miss Becker, thus preventing any real investigation into others.
Thank you, Your Honor. I have no further questions at this time.
All right, thank you, Ms. Kidder. You have cross-examination.
Your Honor, before I begin, may I ask how much time I have left?
You may.
Yes, you have 10 minutes, 27 seconds remaining on my clock.
First, I'd like to talk to you about some things that you said on your direct examination. You said that you looked at the cell tower data from Taylor Perkins' cell phone, but that's not true, is it?
Oh, well, I consulted the Taylor Perkins information, yes.
You don't mention anywhere in your witness statement looking at cell tower data from Taylor Perkins' phone, do you?
I corroborated the information of Taylor Perkins' phone, yes.
You don't say that anywhere in your witness statement, though, do you?
I believe this is asked and answered.
I don't believe that's accurate, so go ahead.
I believe I do, yes.
You believe that that is in your witness statement, Professor?
I have stated that I corroborated the information, yes.
Can you show me where in your witness statement that is?
If you allow me.
Your Honor, improper impeachment.
Ms. Kidder?
Your Honor, it is my understanding that Professor Van Owen never looked into any cell tower data other than what the police had collected. I am merely asking Professor Van Owen to show me if I am incorrect, although we do not have time for Professor Van Owen to go through every single line of their witness statement, so I can move on from this point if you would like.
Well, it's not what my preference is. Let me ask Professor Van Owen, do you have that readily, the location of the basis of your testimony readily at hand?
I do not, but I could try to access it if time allows. But again,
well,
for convenience sake, I don't know how.
All right, well, we'll have to leave that as a dispute. Go ahead, Ms. Kidder.
Furthermore, you stated that the police never investigated Blair Rollins or any other suspects on direct. Do you recall that?
Yes.
But you did review all the evidence that the police collected and created?
Yes, perhaps I should have rephrased that. I do not believe they examined in depth enough alternate suspects.
You also stated that the police never looked for Blair Rollins. Do you recall that?
Yes, they did not do a legitimate search to the nature that I've done as of late.
If you could please turn to what has been marked as Exhibit 17, which you've claimed you have reviewed. And in this exhibit, do you see at the bottom of the box, I believe my co-counsel will highlight that for you, S3 unlocated party Blair Rollins at the rightmost box in the upper corner.
Yes.
Thank you. Now I'd like to talk to you about who is paying you in this case. In your entire career, having worked on 100+ cases, you've only ever worked for criminal defendants, isn't that right?
As a private investigator, that is my job.
And of those 100+ cases, only working for defendants, you've made you typically charge somewhere between $6,000 and $10,000 per case, correct?
As that is my source of income, yes, I have a fee, as expected.
And so, doing the math with these numbers, that means you've made somewhere between $600,000 and over $1 million as a defense expert, in addition to your salary as a professor, correct?
That is correct. Again, it is my occupation. I am being paid for it.
Now I'd like to talk to you about your experience with the police department in Aurora. You left that department after only 9 months, correct?
That is correct, yes.
And you left, and that resulted in a lawsuit that the city had to settle, correct?
Yes, unfortunately, as I alluded to, during the arrest of a detainee, using a allowed technique of apprehension, I injured a detainee. And in that process, while I was excused of the crime, I felt that that showed the systemic issues within the department and led me to my career as a private investigator.
But you were sued personally, weren't you?
Yes, as I think I should have been. It was an injury and I regretted it greatly.
And you never forgave yourself for your actions that day, have you? You just said you regretted it greatly.
Correct, thus leading me to try to reform and find these systemic issues within the police department.
And in your own words, you became disillusioned with police work.
I think that's very
Objection, Your Honor. Improper character evidence. This is presenting a character trait that Professor Van Owen may or may not have a bias towards the police department, and is trying to show that he acted in accordance with that trait on in a certain instance.
Ms. Kidder, do you have a response?
Yes, Your Honor. As opposing counsel stated, we are establishing a bias of Professor Van Owen against the police. We are trying to establish a motive. We're looking into things that really were not substantial in this case, and just making up things and going against what the police had found soundly. And motive is always relevant in a case.
Mr. Littlewood?
I stand by the objection, Your Honor. I believe that this goes towards something somewhat struggling to find the exact phrase, but somewhat more malicious than bias.
Well, I think that the line of questions from the prosecution is attempting to establish that the witness, whether through bias or other means, is going to have a certain slant on his testimony. That may or may not be the case. However, it's certainly something that the jury may consider and something that the prosecution may properly raise on cross-examination, so overruled. Go ahead, Ms. Kidder.
Professor Van Owen, you became disillusioned with police work, didn't you?
Yes, and through my work, I've tried to find the series of issues within their work, as I did within this case.
Now let's talk about the work you did and did not do in this case. You never actually visited the crime scene, did you?
I did not know. I was brought on late to the case.
And my apologies. You also conducted a partial investigation, correct?
Yes, partial again, because I did use the work done by Cusack and Markowitz as a foundation for my own investigation.
And for this partial investigation, you failed to get cell tower records for March 5th, 2020 to see whether Becker and Perkins were where they said they were, didn't you?
To reiterate, I did find Perkins' cell phone tower data and did corroborate that, but I don't inherently want to bring that issue back.
Did you create a witness statement in this case, Professor?
I did, yes.
If you could please turn to that witness statement.
Yes.
And if you could see on the last page, if you look at the very bottom of that page, you'll see a signature. Could you just verify for the jury that that is your signature?
That is mine, yes.
Now, if you look at page 54, line 221. And on that line, you say, in hindsight, I could have also obtained the tower records for the day prior to the murder in order to confirm Becker and Perkins had been in the same locations the day earlier. Did I read that correctly?
That is correct, but I'd also cite the start of that paragraph in which I referenced my investigation to Detective Mark's investigation.
Thank you. For your partial investigation, you also failed to get account records for Mr. Brackman's ring device, didn't you?
Again, that would have been work that should have been done by the police before my own involvement.
But you did not do that when you realized the police had failed to do so.
No, I did not.
Next, let's talk about some more of your criticisms of police work. First, the scuff marks. You've stated marks like that could stay uncleaned by a homeowner for up to 5 years. Isn't that right?
Well, I specifically say that you cannot carbon date them, meaning that we don't know whether or not they came from the night of the murder.
About those scuff marks, you have stated that they are the only apparent evidence of a struggle.
Oh, yes, and that is what Cusack uses as the sole source of a conflict at that door.
In your report, you never mention a broken plate, do you?
I do not know.
But you are aware that there was a broken plate in the home?
From Cusack's testimony?
And from every report that you reviewed?
Yes, I reviewed the work done by Cusack and Markowitz.
You never mention that broken plate in your report, though, do you?
I do not know.
You also never mention an overturned chair in your report.
I do not know. Again, unfortunately, I was not there at the scene of the crime and had to rely on the evidence provided by Markowitz and Cusack.
But you did look at their evidence?
I did examine it, yes. And I specifically focused on what I thought was most pertinent.
You've seen the videos of the intruder in this case, correct?
I have, yes.
And it is your testimony that somewhere in those sweatpants and hoodie, the intruder was carrying a very sharp 12-inch chef's knife.
I have no way of seeing through clothes, so I cannot say whether or not they had a visible knife on them because, again, it's very possible they had a knife on them, yes.
But that is your testimony that they carried a knife into the house?
I do believe that the intruder had a knife on them, yes.
And it is also your testimony that the intruder who carried this sharp, large chef's knife into the house, planning to kill Mr. Brackman, left the murder weapon right there in the crime scene.
Your Honor, speculation. And in addition, facts not in evidence. This question referenced that the intruder was planning to kill Mr. Brackman. This is speculation since no one here can speculate as to what the intruder intended once they entered the home. And in addition, this fact has not been entered into evidence and therefore cannot be included as a stipulated part of the question.
Ms. Kidder?
Your Honor, I am asking this witness to testify about their own beliefs and conclusions in this case. That is not speculation. And as I am asking them to testify about their conclusions, we're entering the fact into evidence as I'm doing the examination.
Your Honor, I would merely ask that they withdraw the part of the question referencing that the intruder intended to kill Mr. Brackman.
Ms. Kidder?
Your Honor, I believe that is a very large part of the defense's case, but if they would like, I could withdraw that portion.
Please do so.
So it is your testimony that this intruder who carried the knife into the house for whatever reason left the murder weapon right there in the crime scene.
I do believe, yes.
You do admit, however, that Mr. Brackman had a complete set of knives in a block except for one slot that was large enough for a chef's knife.
Correct. A chef's knife did not align with the one found with Mr. Brackman.
They never found a chef's knife that matched the others in the block, though, did they?
They did not, but again, the one that was found with Mr. Brackman did not match the description of all the other knives.
You also acknowledge that there was a knife drawer wide open in the home, correct?
That is correct, yes.
And further, you admit that Avery Becker is the same size and build as the intruder.
Yes, as is Blair Rollins.
You also agree that the cell phone records show that Ms. Becker's phone was near Mr. Brackman's house during the time of the murder?
I do, but to reiterate, that does not mean that Avery herself was there.
Professor Van Owen, you have previously stated it is Investigation 101 not to assume things. Do you recall that?
Sure, yes.
However, don't you state it is likely Becker's phone was deactivated?
Yes.
And you also believe that Blair Rollins could have committed this crime?
I think, again, to reiterate, Blair Rollins was a very legitimate suspect who warranted greater investigation from the police department.
But those are your words, aren't they?
Yes.
And you also believe that the intruder carried the knife into the house despite there being no evidence to support that, don't you?
Again, in the videos, there are no visible knives, but that does not mean that there's not one on the intruder.
Finally, about this person, Blair Rollins, you believe they have a stronger motive against Mr. Brackman, but you have no evidence that Blair Rollins even harbored resentment towards Mr. Brackman, do you?
I think it's a fair assumption given that Blair Rollins was the son of a convicted client of Mr. Brackman's.
Professor Van Owen, I would like to remind you, you just said it is Investigation 101 not to assume. Am I hearing you correctly that you just said it's a fair assumption?
I think it's a legitimate thing that should have been investigated by the police department.
Thank you. No further questions, Your Honor.
All right, thank you. Mr. Littlewood, do you have any redirect within the scope of the cross?
Yes, Your Honor. I'd like to start by addressing the improper impeachment which occurred on cross. If I may share my screen so that I may show you what has been previously marked as your witness statement. Is this your witness statement, Professor Bowen? And if I may direct your attention to...
Objection, Your Honor. Improper use of a witness statement.
How so?
Witness statements can only be used to impeach or refresh, so this is either an improper impeachment or an improper refreshment, as opposing counsel is attempting to do neither.
Your Honor, if I may respond.
Yes.
On cross, the opposing counsel attempted to do an improper impeachment and then stopped in the middle because they didn't want to spend time actually going through the witness statement to show whether the evidence was in the witness statement. I am merely trying to undo this improper impeachment by showing that the evidence is in fact in the witness statement.
Well, setting aside the characterization of the proper or improper effort to impeach, I think it is fair, Ms. Kidder, that since you used this statement to attempt to impeach the witness, and it was clear from the witness effort to respond fully to your question, which you cut off, it is fair to allow the witness the opportunity to complete that testimony on the basis of this document. So, overrule.
Professor Van Owen, if you will read along with me starting in line 210. For each of the calls or texts involving Avery Becker's phone shown in exhibits 15 or 16, there was a corresponding call or text from Taylor Perkins' phone at the same time relayed by tower 1191 antenna 2. Antenna 2 covers the mall, and the calls and text from Perkins' phone is entirely consistent with Becker and Perkins calling and texting the phone.
Yes.
Thank you. Would you categorize that as a review of Taylor Perkins' cell tower records?
I would, yes. As I was attempting to say, by using the information within Markowitz data, I found the evidence of Perkins' phone, yes.
Thank you. Now, moving on. Are you being paid to testify in court today?
I am, yes.
Is it normal for private investigators to be paid to testify?
It's a part of the job, yes.
And when you've testified in the past, what side of the case have you testified for?
Like I was saying, usually defense to balance out, since the police are usually heavily on the side of prosecution, and I want to find the extra information found from certain crime scenes that usually the police department misses.
And is it normal for private investigators to only testify for the defense?
Commonplace, yes.
I'm going to ask you some questions now about who was responsible for certain parts of the investigation that did not take place.
Certainly.
At the police department, whose job would it have been to view Taylor's cell tower data?
Detective Markowitz.
Whose job would it have been to investigate Blair Rollins?
Markowitz.
Whose job would it have been to find Blair Rollins?
Detective Markowitz.
Whose job would it have been to see whether Brackman had push notifications on for the Ring app?
Markowitz or Kuzak.
And who was in charge for the police investigation in this case?
Detective Markowitz and the police department.
Thank you, Your Honor. No further questions.
All right, thank you. Ms. Kidder, do you have any recross within the scope of the redirect?
No recross, Your Honor.
All right, thank you. Then the witness is excused.
Thank you.
And the scoring judges may mark their score sheets and let me know when that's done.
My scoring is complete, Your Honor.
Thank you.
I'm done, Your Honor.
Thank you.
I'm done too.
All right, thank you. Does the defense have any further witnesses?
The defense rests, Your Honor.
All right, thank you. Then we will move to closing arguments. Prosecution, you may commence.
Your Honor, before I begin, I would like to reserve any remaining time I have for my rebuttal.
Okay.
Motive to commit mischief, which resulted in a murder. The defendant had a motive for getting into Mr. Brackman's house and vandalizing it. Once inside the house committing this crime, which the law calls criminal mischief, she was surprised. And although she didn't intend to harm Mr. Brackman, a struggle ensued, and Mr. Brackman ended up with a knife in his back. His death is murder under the law. Good evening, members of the jury. My name is Rachel Kidder, and for the next few minutes, I will show you how the people have established beyond a reasonable doubt that Avery Becker is guilty of second-degree burglary and first-degree murder. First, the elements of second-degree burglary. Under jury instruction number 8, we must prove that the defendant knowingly broke an entrance into or entered unlawfully in a dwelling with the intent to commit the crime of criminal mischief against another person or property. Criminal mischief means damaging the real or personal property of another person. Let's look at the evidence for burglary. The defendant had already vandalized Mr. Brackman's car and was planning something worse for the house. She outlined her intent to do so in the text you saw in Exhibit 14. You also heard that the defendant told her mother, "I will get back at Brackman if it is the last thing I do." The defendant's call detail records put her at the scene of the crime during the murder, and the Ring security footage shows someone the same height and size as the defendant entering and exiting the home. The people have proven second-degree burglary. Next, under the elements of first-degree murder, jury instruction number 7 requires us to prove that the defendant committed or attempted to commit second-degree burglary. And in the course of this crime or in immediate flight therefrom, someone was killed. Here we have proven that the defendant's presence in the home was a second-degree burglary. The evidence showed the defendant was surprised by Mr. Brackman, may have even attempted to flee, but a struggle ensued and Mr. Brackman was killed. That, members of the jury, is textbook first-degree murder. When you review the jury instructions, you will see that motive is not an element of either crime, but it is an important factor in determining who did this crime. And we have shown you the substantial motive the defendant had by using her own words. You heard from Alex Cifuentes, Taylor Perkins, and even the defendant herself that she was criticized by Mr. Brackman, causing her to vandalize the car. Then when kicked off the team completely, she planned to vandalize the house as well. Members of the jury, today the defense tried to tell you that the screenshots and cell tower data weren't enough to prove the defendant was there. It's circumstantial evidence. We acknowledge that. However, under jury instruction number 4, the law treats both direct and circumstantial evidence the same. Next, the defense tried to tell you that the defendant lost her phone and didn't notice it was missing. Members of the jury, I would like you to think of all the teenagers you know that let their phone out of their sight for more than an hour. That list is non-existent, right? And finally, the defense brought to you an alibi witness, Taylor Perkins. Both the defendant and Mr. Perkins claim they were together all day on March 6th. Jury instruction number 3 tells us you may believe all of the testimony of a witness, part of it, or none of it. You heard Perkins admit he stepped down from the mock trial team to give Avery Becker what she wanted. You also heard Perkins admit that he met with Avery Becker after he found out he would be a witness at trial today. Taylor Perkins is covering for his best friend, and you need to disbelieve his testimony. As for the defendant, you heard that she lied to her own mother, and anyone who can do that can certainly give false testimony to this jury as well. You need to disbelieve her testimony. There is no evidence for this alibi. The evidence that was admitted in this case tells us that the defendant's motive to commit mischief resulted in a murder. Members of the jury, it is not the people's burden to prove to you that the defendant is a bad person. Of course, it's human nature to want to convict only bad people, but it is your duty as jurors to review the evidence and apply the jury instructions as the court gives you. The evidence did not show Ms. Becker intended to kill Mr. Brackman, but she did intend to commit criminal mischief, and a death occurred. Members of the jury, at the end of your deliberations, we ask that you find the defendant guilty. Thank you.
Thank you. Mr. Littlewood, you have the closing for defendant.
Thank you. Are the timekeepers ready?
Yes. Yes.
Thank you. Members of the jury, the mere fact that we are here in court today is a gross miscarriage of justice by the Denver Police Department. Humans are complex creatures with complex problems. The police investigation in this case is an effort to turn a complex problem into a simple one by simply neglecting to consider all the evidence. From the beginning of the investigation, Markowitz and Kuzak made up their minds about who they thought had committed this crime and followed only the lines of evidence which suited their premature conclusions, despite the fact that these conclusions do not make sense in context and carry more than a reasonable doubt. Now, in every foundational piece of evidence to the prosecution's case, they have failed to properly establish that evidence. The most important piece of evidence to their case, in fact, the only piece of evidence which could potentially tie Avery Becker to this crime, is the series of text messages provided by Alex Cifuentes. As evidence of these messages, we have only the screenshots provided to the police by Cifuentes. These messages do not show the time, nor the date, nor the phone number of the sender, and now based entirely on Cifuentes' word that these messages were received from Avery, the police are trying to convict an innocent person of a crime she did not commit. Searching Cifuentes' phone to verify the validity of the messages would be well within the rights and abilities of the police, but they neglected to carry out this vital step of the investigation. This cannot be held up in court as an imitation of a proper investigation. In addition to failing to properly establish their own evidence, the police have also made far too much of evidence they were able to properly collect while conveniently ignoring evidence which did not suit their theory. The police used cell tower analysis of Avery Becker's phone to try to show that her phone was at the mall when the murder occurred. My apologies, at the victim's house when the murder occurred. However, cell tower analysis cannot be relied on to show the exact location of a device. And even so, Avery was not in possession of her phone at the time, having lost it the previous night. At the time of the murder, Avery and Taylor were at the mall searching for her lost phone, an alibi the police completely neglected to investigate. Police could have looked at Taylor's cell tower data to substantiate this alibi, but once again, they neglected to do so. However, Professor Blake Van Owen did view the data, and Taylor's cell tower data shows that they were at the mall when they claimed. Now consider this. In either theory of this case, someone has to be lying. In the prosecution's theory of the case, Taylor Perkins is lying about Avery Becker being with him at the mall when the murder took place. And in the defense's version of the case, Alex Cifuentes is lying about being sent these messages by Avery. No evidence exists to prove that Cifuentes received these messages from Avery. But Taylor Perkins' cell tower data does prove that they were at the mall when the murder took place. The police elected to ignore this fact because it does not suit their premature and unfounded theory. Now, Avery Becker, in all reality, is just a kid, a sweet, innocent person. And yes, when she got kicked off the mock trial team, she was angry. but it is completely absurd that a simple and harmless disagreement over something as mundane as mock trial is being presented as a motive for murder. The burden of proof today is on the prosecution. They must prove beyond a reasonable doubt that Avery Becker has committed these crimes. You may find reasonable doubt in their inability to establish the validity of the text messages, in their firm resolve to ignore any evidence which did not suit their theory, in the absurdity of a mock trial dispute being presented as a motive for murder, or in the glaring fact that at the time of the murder, Avery Becker was with their friend Taylor Perkins at the mall. And as everyone knows, you cannot be in two places at once. This investigation is a gross miscarriage of justice, a window into the incompetencies of the Denver Police Department, and an effort to explain a complex problem with a simple solution that simply doesn't fit. Nothing about the prosecution's theory of this case makes sense. Return a verdict of not guilty. Thank you.
Thank you, Mr. Littlewood. Ms. Kidder, you have, I don't know what time, what is the time left for rebuttal? 39 seconds. Go ahead, Ms. Kidder.
We are complex people and we have complex problems, but we also tend to have animalistic tendencies. Ms. Becker had committed vandalism before and she was planning to do it again. The defense also tried to tell you that cell tower data is extremely unreliable, but then they turned around and tried to use that same data to prove the alibi of their witness. Either they were lying to you then or they're lying to you now, but either way, they are trying to mislead you, members of the jury. We ask that you find the defendant guilty of second-degree burglary and first-degree murder. Thank you.
Thank you. The case will stand submitted. The timekeepers need to complete their score sheets and then when done, submit them. Please let me and Maureen know when you have submitted them, and then we will wait for verification from command headquarters that we're all set. And after this, we'll have an opportunity for some brief feedback, commentary from the scoring panelists.
Well, Your Honor, I'm trying to submit, but it doesn't seem to be going anywhere.
The totals complete.
Can they tell if it's been submitted? I can't tell if it went.
They are supposed to notify me when
Okay.
all of the sheets have been submitted.
Okay.
All right.
I'll just wait and see then.
Okay.
My score's been submitted, Your Honor.
All right, thank you.
My score has been submitted too.
All right, thank you. Then we will wait and see if they get back to Maureen. Holly and Dahlia, could you tell that your sheets were submitted?
Yes, Your Honor, it still shows the score sheet, but it doesn't have the fields for editing after you hit submit.
Same for me.
Okay, does that help? Judge Dunn, whether that shows that you've been submitted?
Yes, mine was paused for a while, but it looks like it did go.
Okay, good. Then we'll just wait for confirmation.
Okay, they got all three of them.
All right, why doesn't everybody bring up their pictures so that Mr. Schneider doesn't have to look like he's in a hostage video anymore? All right, thank you very much. I thought that was a good round. Scoring judges, Dahlia, do you want to go first?
Sure.
Yeah, I'll give you 2 minutes, and I'm going to enforce time limits on you as I did with the contestants. So 2 minutes starting now.
Okay, great. I just wanted to praise everybody for a great job. I think I like both stories, both sides of the story. I could see myself being in the jury box and being a little, being persuasive either way. I think witness control was precise. I didn't think sometimes witnesses can get hostile, and I think that the way that you handle by saying thank you, I think it was a good witness control. Didn't see anybody get disrespectful with a witness, and that usually doesn't go well with a jury. So I think that was great. My background is in criminal defense, so I practice criminal law, and I think that you all have a good path to get there if you guys want to pursue a career in law. So I will advise you to do that. I think everybody was phenomenal. So great job.
All right, thank you. Holly, do you have some comments?
Yes, I can definitely see why both teams have made it this far. You did an excellent job with witnesses and questions, some unique objections that got my attention. Very good witness control. My background has been commercial and residential real estate law for about 25 years. And that moved me into a position to be the Jefferson County Public Trustee. So even if you look for something after law school, it doesn't necessarily mean you have to be a lawyer in court. There's a lot of fields you can go into, or like mine, where I fell into it after you go to law school. So good luck, keep it up. Great job, you guys.
All right, thank you. Judge Dunn, do you have some comments?
Briefly, I know you guys have had a long day. Congratulations to everyone and their coaches for making it this far. Nicely done. That was a tough round. You all are on your A game. Here's a couple takeaways. I can't get to everyone, but Mr. Littlewood, your redirect of Van Owen was particularly effective. That series of questions where you just kind of nailed the key points in terms of the flaws in the investigation. Team Mexico, mischief, murder, that theme that you looped from the opening and the closing, excellent. It was a catchy theme. You, Miss Wynn brought it up in opening. Miss Kidder closed with it. It was very, very effective. Miss Kidder, with your expert, you were very sensitive to the time issues. You quickly qualified. You did a great job with limited time. So very, very good job. Miss Wynn, you had a very difficult evidentiary situation come up. You handled it with composure and grace and professionalism. So well done, everyone.
All right, thank you very much. I thought as well that this was a very well acted out round, that you were all on top of things. And I have just a couple of comments that I'd like to talk to each of you, but I'd like to call out Ms. Kidder. I thought your closing was particularly good in drawing out and identifying why the burglary and the intent to commit burglary was important to the case and how it was not important to the murder charge. Mr. Littlewood, and this is something that it's going to be slightly critical. I don't mean it to be vastly critical, but it's something that I think applies to everybody. When you were conducting your examination of Van Owen, at one point you said that there were 2 points you wanted to raise with him. One was the scuff marks and the other was the knife. And from what I heard, and maybe I missed something, but you talked to him about the scuff marks, but I didn't hear anything about the knife. And so the point is that if you raise expectations in your presentation, it's important to satisfy those expectations and make sure you tie off the points you were making and the facts that you want before the jury. Other than that, I know, as Judge Dunn said, you guys have had a long day. You got to get some sleep, rest, food. Come back tomorrow, do it again, and congratulations on a great round. Thank you very much. You do deserve applause, and the one thing about this Zoom is that we sort of break off quickly. And it's a sharp break, but congratulations. Thank you.
Thank you. And I think I speak on behalf of my entire team when I thank the judge and all of the jury members for taking the time to do this for us. I know it's hard for you guys too to sit there and listen.
Oh, it's good. It's a lot of fun. You guys do a great job. Thank you.
Thank you so much.
Bye. Thank you.
Thank you so much.
Thank you.